Yes, Mr. Valerie.
As the court, please, my lord, we confirm appearances on behalf of the state.
Yeah.
I confirm my appearance on behalf of Mr. Sibiya and Mr. Minobe.
Able. Mr. Court, this is my lord. I did confirm my appearance on behalf of Mr. Ballistics. All right.
Please, the court, my lord, I still confirm my appearance on behalf of Mr. Maphisa.
Okay.
Thank you.
Thank you, Madam. I confirm my appearance on behalf of number 5. Thank you.
Okay, thank you. Yes.
As the court, please, my lord, the matter is set down to today for hearing of arguments by accused number 1's counsel for discharge in terms of section 174, as well as the response of the state to that application. There were time lines that were set down for the submission of the heads of argument by the counsel for accused number 4, as well as for the state. Both parties have adhered to the timetable,
Yes.
and hard copies, my lord, have been prepared for the court, and
Meyiwa was a well-known professional footballer who played for Orlando Pirates as a goalkeeper in the Premier Soccer League and for the South African national team Bafana Bafana. The deceased was shot and killed in the house of his ex-girlfriend, Miss Kelly Kumar, on the 26th of October 2014 while paying her a visit. On the 16th of June 2020, the investigating team led by Brigadier Geninda, who is the head of the National Court Cases, arrested Bongani Ntanzi, accused number 2, in respect of this case. On the 19th of June 2020, accused number 2 made a confession statement before a commissioned officer, Colonel Rapado. On the 24th of June 2020, accused 2 made a second confession statement before a magistrate, Ms. Cronje. It was on this basis that a confession statement which led to the arrest of accused number 4 before court. On the 17th of July 2023, the trial commenced de novo, and it has been on a running roll for a period of over 2 years. It has been televised, national and international, and on print. It has also been marked by delays during this period. Accused number 4 has been in attendance throughout the trial. It is no doubt that at some instances, valuable court time has been wasted. The rationale for section 174. The rationale for the rule in terms of section 174 was described as in State v. Morero, unreported GP case number A523 of 2015, dated 22 January 2016 at paragraph 54. And I quote, "It caters for the prescript of the Constitution for the fair criminal trial, namely the presumption of innocence on the part of an accused until proven guilty and his or her right to silence. It further puts an abrupt end to a case which has no prospect of being successful in circumstances where the evidence falls abysmally short in proving even a prima facie case against an accused, thus ensuring that valuable court time is not wasted and unnecessary expenses not incurred." Section 174 thus gives the court to decide not to put the accused on his or her defense if there is no case to answer. There is no formula for or test applicable to all circumstances when deciding whether or not to discharge. Each case must be decided on its own merits in order to reach a just decision. The charges. The accused, including accused number 4, are charged with the following offences.
Mthokosiziseni Maphisa ngaphansi kozomthetho section 174 ekuthizeni umdedele kumacala wonke abakade bemthosa wona ke lapho ke lasho khona ukuthi lesi isicelo siwela ngaphansi kozomthetho lapho ke section 174 ngaphansi kozomthetho la 9 iningizimu Afrika ke ngaphansi ko act 51 ezomthetho ka 1977 lathi khona ke egcineni kwicala ke lozombuso ke uma ngaba ke khona kanjalo ke lokuzana ke bebona ukuthi abanalo icala lapho ke komethi abasolwa ke badedelwe ke mana namcala la kade bebathosa wona ke lapho ke futhi abathole bengenawo kamacala ke futhi washo khona njalo uma befunda lapho ku background ngaphansi kwe background lapho ke bathi khona kanjalo umuntu washona ke lapho ke uSenzo Meyiwa ke kade saziwa kakhulu njengomdlali webhola ke futhi edlala njengo goalkeeper ke lapho ke sokuthi umdlali kodwa edlala ngaphansi kwamapale futhi edlala iqembu leOrlando Pirates futhi edlala ngaphansi kona ke Premier Soccer League futhi neqembu lanake iningizimu Afrika ke labafana ke bathi wadutshulwa ke ngelanga la wadutshulwa emzini we ex girlfriend yakhe uShiti Ntombi ke kadathandana nayo ke lapho ke uKhili Khumalo ngelanga la nge26 zakaOctober ngomnyaka 2014 ngesikhathi kade amvakashele khona ke kumuzi wakhe ke lapho ke bathi futhi ngelanga la nge16 zakaJune ngomnyaka ka2020 khona ke njalo ke ithimba labashushisi ithimba labaseshi ke lapho ke kade laholwa ke lapho ku Brigadier Gininda ke ilona ke osebenza ngaphansi kwama cold cases wabopha khona njalo bopha khona lapho ke Bongani Ntanzi ke ngokomsola wesibili ke lapho ke bese ngelanga la nge19 zakaJune ngomnyaka 2020 lapho ke umsola wesibili ke bese wabhala ke statement noma wenza ke confession ke eyenza ngaphansi kwe commissioned officer ekukade ku Colonel Rapado lapho ke ngelanga la nge24 zakaJune ngomnyaka 2020 ke lapho ke umsolo wesibili bese wabuya futhi wenza confession yesibili ke lapho ke noma statement ngaphansi kwamanje ke lapho ke uMr Kronje lapho ke ekhuma khona ngaphecelezi ngodaba le-confession lapho ke la kade khona ke futhi ngemuva kwalokho kwe-statement zakhe azenzile lapho ke wagcina sekuboshwa khona ke njalo lapho umsola wesine ke lapho ke bathi khona njalo ke ngelanga la nge17 zakaJuly ngomnyaka 2023 khona ke lapho ke icala lela qala ke phansi lahlala phansi lapho khona bese lahamba lihlala khona njalo ke bathi sekuphile ke isikhathi seminyaka ke emibili ke icala likade likhunya khona njalo ke futhi icala likade belikhambisile mhlambe belikhangisa kumabona kude ke lapho ke balana ke iningizimu Afrika futhi ngisho nangaphesheya kwelwandle lapho ke futhi nangaphansi kuma print media basho khona njalo ke khona ke kade khona ke inamba ekade zikhona ke lapho ke ezenza ukuthi icala lingahlali ngesikhathi esanele mhlambe kade khona kuphazamisa phakathi kwicala leli ke lapho ke basho khona njalo uma ngabe sesikhuluma ngesicelo lesi saka section 174 khona ke lapho ke bathi khona njalo uma siyoqhathanisa phakathi kwicala lika SF icala kambuso ke futhi libhekane khona ke lapho nomurero bathi khona ke kade lingareportiwe lapho ke elalana ke eGP wathi ngaphansi kwe-case number A523/2015 date la nge-22 zakaJanuary ngonyaka 2016 lapho ke ummeli kade aqhathanisa nje kuphela kulelo cala leli nakecala lesikulona ke uthi kasho khona njalo ukuthi ngesikhathi bekafunda futhi washo khona njalo ukuthi ngaphansi kwezomthetho ka section 174 uma ngabe ke umsola mhlambe umsola okuwesilisa noma usifazana noma usimameke lapho ke bengenalo icala lokuthi aphenduleke lapho ke lokhu kuvanga ukuthi mhlambe kusetshenziswe ke khona ke lapho ke ngaphansi kwento ekusuke mhlambe benayo ehlangothini lezombuso ke lapho ke.
The accused, including accused number 4, are charged with the following offences. Murder read with the provisions of section 51, subsection 1 in bracket of the Criminal Law Amendment Act 105 of 1997 as amended, and further read with sections 92 subsection 2 in bracket 94, 256, 261 of the Criminal Procedure Act 51 of 1977. In that upon or about the 26th of October 2014 and at or near Fostoras in the district of Boksburg, the accused did unlawfully intentionally kill Mr. Senzo Meyiwa, a 27-year-old male, by shooting him with a firearm. The provisions of section 51 subsection 1 in bracket of Act 105 of 1997 are applicable in that the murder was planned or premeditated. B, the death of the victim was caused by the accused in committing or attempting to commit, or after having committed or attempted to commit robbery with aggravating circumstances, as defined in Section 1 of the Criminal Procedure Act 51 of 1977. C, the offense was committed by a person, group of persons, or syndicate acting in the execution or furtherance of a common purpose or conspiracy. Count 2, attempted murder. In that upon or about 26 October 2014, and at or near Fostoras in the district of Bosbeck, the accused did unlawfully intentionally attempted to kill Zandile Lorraine Kumad, an adult female person, by shooting at her with a firearm. Count 3, robbery with aggravating circumstances as defined in Section 1 of Act 51 of 1977, read with the provisions of Section 51, subsection 2 of the Criminal Law Amendment Act 105 of 1997, as amended, and further read with Sections 92, subsection 2, 94, 256, 261 of the Criminal Procedure Act 51 of 1977. In that upon or about 26 October 2014, and at or near Fostoras in the district of Bosbeck, the accused did unlawful intentional assault Miss Kelly Kumalo and or Gladys Kumalo, and did with force and violence take a Samsung S4 cell phone, the property or in lawful possession of Miss Kelly Kumalo and or Gladys Kumalo, and did rob her of same. Aggravating circumstances being present in that the accused made use of a firearm. The provisions of Section 51, subsection 2 of Act 105 of 1997 are applicable in that there is presence of aggravating circumstances. Count 4, contravention of Section 3 of the Firearms Control Act 60 of 2000, possession of firearm. In that upon or about 26 October 2014, and at or near Fostoras in the district of Bosbeck, the accused did unlawfully and intentionally have in their possession a firearm to with a 9mm CZ model 75 with obliterated serial number without being in possession of a license to possess the said firearm. In respect of this count, the state alleges that the accused jointly possess a firearm which is the subject matter in this count. Count 5, contravention of Section 90 of the Firearms Control Act 60 of 2000, possession of ammunition. In that upon or about the 26th of October 2014, and at or near Fostoras in the district of Bosbeck, the accused did unlawfully intentionally have in their possession an unknown number or quantity of 9mm parabellum caliber ammunition without being in lawful possession of a firearm capable of firing such ammunition.
Kana ke bafola ke phefala namacala alandelayo ke futhi ke nomsolo wesine ke qala ukubulala ke lapho ke elwela ngaphansi kwezomthetho section 51 subsection 1 kwezomthetho lana eNingizimu Afrika ke wela ngaphansi ko Act 105 of 1997 futhi uma siqhathanisa uma sihanjiswa neminyaka ezemithetho ke lapho ke ingaphansi ko subsection 92 subsection 2 94 256 futhi no 261 Criminal Procedure Act 51 of 1977 la bathi khona ke ngelanga la nge20 bathi ngelanga la nge26 October eduze nendawo seFostoras ke lapho ke noma ngaphansi kwesigodi sase Bosbeck ke lapho ke bathi khona ke khona njalo umsolo abasola benza lokhu futhi ngongemthetho futhi ngenhloso ngesikhathi kade bebulala khona ke lapho ke uSenzo Meyiwa kade weneminyaka ke u27 usuthi amashumi amabili nesikhombisa ke ubudala ke futhi wesilisa ke bathi ngesikhathi kade edutshula ke lapho ke ngesibhamu ke lapho ke bathi lokukula ke ngaphansi kwezomthetho ke lapho sika 51 subsection 1 Act 105 of 1997 usuthi lapho ke usuthi umuntu usuthi lokubulala kwabo ke bahlela phansi noma bacabanga bese bahlela phansi ngesikhathi kade bekwenza bekwenza ke lapho ke futhi yabuya futhi aqhubeka khona zathi ukushona kukamufi ke lapho ke kwakuyimbangela ukuthi kade khona ke abantu abangena bese bebenza lokudlala nobugebengu kade babenza ngaphakathi ke lapho ke noma bezama ukuthi babambe inkunzi lapho ngesikhathi futhi bebamba ke inkunzi kade ephetheke ikhali ke kubona ke bade kokwela ke inkunzi futhi ngaphansi kwesection 1 wezomthetho ngeNingizimu Afrika ke like Criminal Procedure Act 51 of 1977 la bathi futhi khona ke njalo kusho lamacala ke la kade enziwe khona ke lo muntu oyedwa ke noma mhlawumbe iqembu ke labantu kade lisebenzisana lonkana ke ekuthizini bafezekise lokuzana isifiso sabo sokuthi benze lokho mhlawumbe ukuhlela ke ukubulala ke lapho ke bathi icala lesibili ke lapho ke ukuzama ke ukubulala ke bathi ngelanga lenge-26 zaka-October ngomnyaka ka-2014 duze nendawo yaseFostorus noma ngaphansi kwesigodi saseFostorus bese ngaphansi kwendawo yaseBoksburg ke lapho ke bathi ke abasolwa mhlawumbe kumsolwa wenza lokho ngengemthetho futhi ngenhloso ke la kade zama khona ke ukubulala khona ke lapho ke uZandile Lorraine Khumalo ke okade kuumuntu wesimama ke omdala ngesikhathi kade bemdubula ke bemdubula bese kade kusetshenziswa ke isibhamu ke lapho ke bathi futhi icala lesithathu ke lapho ke ukubamba inkunzi ke lapho ke niqhobile mhlawumbe bephetheke ikhali kinina ke ezinobungozi ke lapho ke bathi sikhona ke lokho kukhulunywa ngaphansi kwezomthetho zaka section 1 Act 51 of 1977 futhi ifundeka nezinye ke zemthetho ke lapho ke section 51 subsection 2 yezemthetho lana ke eNingizimu Afrika ke lapho ngaphansi kwezomthetho zaka Act 105 of 1977 futhi uma sejobelelwa ke ihambisana ke nezinye neminye ke imithetho ke lapho ke isizohamba ke no section 92 subsection 2 section 94 section 256 futhi no section 261 yezemthetho lana ke eNingizimu Afrika ke wela ngaphansi kwezomthetho ke 51 of 1977 laba thi khona ke ngelanga lange-26 zaka-October ngomnyaka 2014 eduze nendawo noma ngaphansi kwendawo seFostorus ngaphansi kwesigodi saseBoksburg khona ke lapho ke la khona ke abasolwa benza khona ke ngongemthetho futhi nangenhloso ke ngesikhathi kade bezama khona ke lapho ke ukuthizeni besenza lokho kade bekwenza kulapho kuMiss Kelly Khumalo noma uGladness Khumalo ngesikhathi kade bemphoqa ke lapho ke noma ngongemthetho bemthathela lapho kumakhala ekhukhwini wakhe kade kuyiSamsung S4 cellphone yakhe ke lapho ke futhi kade kuye yakhe ke bayithatha ngaphandle kuthina ke abavuma ukuthi bayithathe ke lapho ke bamba ke inkunzi lapho ke uKelly Khumalo noma uGladness Khumalo ke lapho ke ngesikhathi kade nithathela lokho futhi kade nisebenzisa ke nakhe lapho ke isikhali ngesikhathi kade nisenza lokho ke bathi lokho khona ke ngaphansi kwezomthetho zaka section 51 subsection 2 Act 105 of 1977 yezomthetho shothi lapho ke iyangenelela phakathi ke lapho ke la bathi khona ke nina kade nisebenzisa ke isikhali ngesikhathi kade nisenza lokho ke bathi icala lesine nibukene nalokho icala lokutholakala ke niphethe ke isibhamu icala lolwela ngaphansi kwezomthetho ke noma kungahambisani nomthetho section 3 umthetho wezibhamu ke lapho kwela ngaphansi ko Act 60 of 2000 sokunatholakala lapho kuniphetheke izibhamu ngemthetho ke bathi ngelanga lange-26 zaka-October ngomnyaka 2014 duze nendawo noma ngaphansi kwendawo seFostorus bese ngaphansi kwesigodi lapho saseBoksburg bathi khona ke abasolwa benza lokho ngemthetho futhi ngenhloso ke ngesikhathi ephethe khona ke kubona ke isibhamu kade kuyi9 mm CZ model 75 lapho kade inombolo zakhona ke kade zicishiwe zingasabonakali kahle ke kuleso sibhamu leso ke inade nesiphethe futhi ngaphandle kokuthi liphetheke amaphepha akade enikeza imvume noma ilungelo ukuthi nisebenzise ke isibhamu ke lapho ke bathi lokho ke iyona ke into ithimba noma ihlangothi lozombuso ke abanishushisa ngayo ke leyo ke bathi futhi icala lesihlanu ke lapho ukuthi nitholakale ke lapho ke ningahambisani ke nomthetho ka section 90 wezemthetho umthetho ezibhamu noma mhlawumbe izinhlamvu ke lapho ke ewela ngaphansi kwe-Act 60 of 2000 la bathi khona ke nina ke ngelanga lange-26 zaka-October ngomnyaka 2014 duze nendawo noma ngaphansi kwesigodi saseFostorus bese ngaphansi kwesigodi noma ngaphansi kwendawo yaseFostorus bese ngaphansi kwesigodi saseBoksburg la kade nina ke nenza ngongemthetho futhi ngenhloso ke lapho ke ngesikhathi kade nitholakala niphethe khona ke lokuzana izinhlamvu eziningi kinina ke inhlamvu lezo kade kuyinhlamvu zelokuzana ze9 mm parabellum caliber suthi isibhamu sakhona ke leso ke suthi lapho bathi inhlamvu zesibhamu leso ke then itholakala niphethe lapho ke futhi bathi inhlamvu leso kade niphethe inhlamvu eziningi ngendlela engajwayelekile noma engavumelekile.
The summary of substantial facts in terms of section 144 subsection 3 in brackets small letter A in brackets of Act 51 of 1977 details amongst others that there were several other persons in the house, namely Miss Gladness Khumalo, the owner of the house, who is the mother to Kelly, Miss Zandile Lorraine Khumalo, sister to Kelly, Mr. Longwe Twala, boyfriend to Miss Zandile Kumalo, Mr. Tumelo Madlala, friend to Mr. Senzo Meyiwa, and Mr. Mthokosiziseni Twala, a friend of Mr. Senzo Meyiwa in the lounge or dining room. A cell phone belonging to Miss Kelly Kumalo was taken and the assailant fled, dropping a head on the premises. It is important, my lord, to mention that in respect of count 3 of the indictment, Ms. Kelly Kumalo was not called to testify despite being the complainant in that count.
Despite what?
Despite being the complainant in that count, in count number 3 of the
I thought there were
indictment.
2 complainants. Mr. Baloyi, is that not so?
Yes, indeed. The other complainant is the mother.
The mother, yeah.
Yes,
Yeah.
both of,
Okay.
in fact, I should say, my lord, that both of them were not called before this court to come and testify about the circumstances of the robbery, which occurred on the 26th of October 2014 in the house in their presence. The state will allege that the accused were acting in the furtherance of a common purpose to commit the crimes as per the indictment. The duties of a prosecutor. In terms of Section 25 of the National Prosecuting Authority Act 32 of 1998, determines the powers, duties, and functions of prosecutors. Section 25, subsection 1, provides that a prosecutor shall exercise the powers, carry out the duties, and perform the functions conferred or imposed on or assigned to him or her, A, under Act 32 of 1998 and any other law of the Republic. B, by the head of the office or investigating directorate where he or she is employed or person designated by such head. Or C, if he or she is employed as a prosecutor in the lower court by the DPP in whose area of jurisdiction such court is situated or a person designated by such DPP.
Kwezinto kade zikhona ke lapho ke usho mhlawumbe isihlahla msindo ke lapho ke lathi khona ke kade khona ke abantu abaningi kade bekhona ngaphakathi kwalo muzi walapha ke futhi uqala kade khona ke lapho ke bathi owesimame lapho Gladness Khumalo futhi yena ke umnini muzi walapho ke kulo muzi walapha kwaKhumalo ke lapho ke bathi wesibili kade khona kuZandile Lorraine Khumalo ke kade kusisi kaKheli ke lapho ke futhi umnade kade kukhona kumnumzana uLongethwala kade kuyi-boyfriend noma sothi ushithi umuntu ohlekisana noZandile Khumalo ke lapho ke futhi noTumelo Madlala ke lapho kade kumngane kaSenzo Meyiwa futhi uMthokosiziseni Twala ke lapho ke naye kade kumngane kaSenzo Meyiwa lapho ke athi bonkana labo bantu kade behlezi ke lapho ke kule ndawo yokuhlala ushithi mhlambi yokuhlala ngaphakathi komuzi ke bathi ngesingisi ke i-dining room ke lapho ke bathi ngesikhathi kade kusenzeka lokhu ke kwathi khona ke abantu ababili ke lapho ke abangena ngaphakathi kwalamuzi kade ngesikhathi kade bengena kade behlubile kubona ke futhi bafuna ke imali futhi nelokuzana namacingo ke lapho ke athi ke lapho ke ummeli ke ukhumbule khona njalo ke ukuthi bonkana labantu ekhunywa ngabo ke lapho ke thize emathatha babakhuthuza lapho noma mhlawumbe babamba inkunzi ke lapho ke abakaze beze bazoletha ufakazi babo ngaphambi kwenkosi enkantolo ke lapho ke futhi uyafunda manje uma uqhubeka efunda khona njalo lapho ke mayana nesikhangiso sakamshushisi ke lapho ke athi mayana nezomthetho ke lapho section 25 owela ngaphansi kwezomthetho ke lapho National Prosecuting Authority lapho ke Act 32 of 1998 uyasho khona njalo uyakhuluma ngendlela kumele abashushisi basebenze ngayo ke uma besebenza malana phecelezi nozomthetho malana udaba lozomthetho ke lapho ke athi ngaphansi kwesection 25 subsection 1 iyona ekhuluma ngephecelezi ngodaba labashushisi ukuthi kumele basebenze kanjani ke amandla wabo ke uma ngabe sebephethe umsebenzi wabo besebenza lapho ke phecelezi nodaba lamacala uma ngabe abashushisi ke lapho ke besebenza sithi mhlambi kuyinkantolo ke incane ke lapho ke noma besebenza ngaphansi nje kokuphenya kamacala noma eksizeni amacala aphothulwe ngaphambi kwenkosi enkantolo ke lapho ke noma besebenzela ngaphansi kwe-DPP ke lapho ke beyakhuluma ngodaba lolo ke kuphela.
A prosecutor has a duty to pay attention to the contents of the police docket. In this regard, see Minister of Police and another versus Duplessis, 2014, Volume 1, SACR 217, SCA. The summary of substantial facts in terms of Section 144, subsection 3, in bracket, small letter a in bracket of the Act. 51 of 1977 details that the deceased, Mr. Senzo Meyiwa, died during or after the commission of the robbery, which gone wrong. Brigadier Kininda, in his evidence, details a hit to kill the deceased and based this argument in the investigation done and or conducted by the investigating team on the following. The evidence of Colonel Lambertus Stein. Colonel Stein testified that he was employed by South African Police Service and in the service of the state, attached to the National Court Case Unit investigation based in Pretoria, National Head Office, where he acted as an analyst and an investigating officer. On the 9th of April 2020, at about 10 o'clock, he received a series of Section 205s and cell phone downloads from the investigating officer, Brigadier Kininda. He testified further that Brigadier Kininda requested him to determine if there are any linkages between the current suspects and the people in the house at the time of the crime. The transcribed record of the 27th of July 2023 at page 64, line 10 to 15, states the following. Mr. Stein, I just want to draw attention to the court that as well that a Section 205 information, not one of the team members applied for that, but it was stored on the central database of the police. So that is why it was being applied for by the previous investigation officers. But we did have access to that.
Yafunda futhi phecelezi nodaba lapho ke lokusebenza lapho ke kwethimba labashushisi ke lapho ke bezobuya qhathanisa phakathi kwecala lapho ke leka Minister of Police futhi nabanye ke lapho ke no DPLC la ngo 2014 volume 1 SACR 217 lapho ke athi khona ke njalo lapho ke athi khona ke udaba phecelezi bathanda ukukhuluma ngalo ke lapho ke uma ngabe khona kufakazi obukhethekile noma ufakazi obabukhethile nocaphulile ekuthizini enza qhathanisa phakathi kwabo ke lapho ke lathi khona ke ukufakaza bukhulunywa lapho kumnumzana uColonel Lambert Stein osebenza ngaphansi kwezesiphoyisa ke lapho ke la bakhuluma khona ukuthi yena ke ngesikhathi lesi ngelanga la nge9 zaka April ngonyaka 2020 ke lapho ngehora la ka10 kusasa ke wathola ke ucingo lapho uqhamuka lapho ngaphansi kwesection 205 ke lapho ke lozo kuzokuthwebula kwemininingwane ngaphakathi kwamacingo ke lapho ke la bacela khona kuBrigadier Kininda khona ke lapho ke athi ukuthi zena umsize ngesikhathi ba testify lapho noma ngesikhathi bekade athula ufakazi bakhe ke lapho ke athi akabheke ukuthi noma ngesikhathi bamcetha akabheke ukuthi ngabe khona yini uxhumana phakathi kwalabantu bekhona ngaphakathi kolamuzini ke ngesikhathi salobugebengu lobuke lapho ke bese ke yacaphula ngaphansi kokushicilelwa inkantolo ngelanga la nge27 zenyanga kaNtulikazi ngonyaka 2023 lapho kwikhasi le64 lapho kumugqa wesi10 ifice kuze kufince kumugqa wesi15 ke lapho ke la umnumzana uStein wakhuluma khona ke lapho ke ekuthizini wacelwa njalo akadobeke lapho kusebenza kwakhe noma ukusebenza ngaphansi kwenkantolo ke lapho ke ngaphansi komthetho aka section 205 lapho ke nemininingwane kade anayo lapho ke futhi ecela amaphoyisa ke lapho ke ekuthizini enze lo daba ke lo mhlambe lo cwaningo lo msebenzi ke lapho ke athi lo ngana lo cwaningo kade beshicelele ngaphansi ku database yezesiphoyisa ke lapho ke athi khona ke njalo futhi leso sicelo kade sisenziwe lapho ke umseshi wecala lapho ke ngesikhathi kade esikusenziwa lokhu ke khona njalo ke.
Then my next point, during my analysis, I discovered that Kelly Kumalo with number 278270444358, she received a call from Ndulinkan with number 277330592003. This appears from the transcribed record of the 27th of July 2023 at page 75, line 6 to 9. According to Colonel Stein, communication between the two numbers occurred on two separate occasions. That is on the 2nd of August 2014 and 15 October 2014. The details of the communication are reflected on page 23 of Colonel Stein's affidavit, Exhibit 01. It is important, my lord, to mention that the information from the central database of the South African Police Services was editable, and the state did not call any witness to authenticate it during the course of this trial. The state, by this communication, that is communication between the two numbers, intended to prove communication between the mastermind, which according to the Brigadier, that is Brigadier Gininda, was Ms. Kelly Khumalo and accused number 5. Accused number 5 then procured the services of his co-accused, that is accused 1 to 4, in the execution of the murder. The evidence of Ms. Pinky Vitilingam.
Lapho sibikasho khona njalo ke iqaphela kunkulumo kade khona lapho umnumzana ke uStenge lapho ke ngaphansi kwekhasi lama-23 ke lapho ke lade qapha khona ke khona ke njalo yena ke into umsebenzi kade awuceliwe ekuthizeni ke awenze lapho ukuthi agqinize kabanzi ekuthizeni enza ama-analysis ke lapho ke phecelezi nodaba phakathi kwakaKhili Khumalo ke kwinombolo zakaKhili Khumalo ke lapho ke kade zihamba ngalo 082 7044 358 lezo athola khona ucingo kuzona ke kade qhamuka lapho ke kuNtuli inkani futhi naye kade enale inombolo ezilandelayo ke lapho ke kade ku 0733059202 lapho khona lokho kade kukhona kushicilelwe ngelanga la nge-27 ngenyanga kaNtulukazi ngonyaka 2023 lapho ke ngaphansi kwe-page lapho ke noma ikhasi le-75 uqala kumgqa wesithupha kuze kufince kumugqa wesi-9 ke lapho ke lathi khona ke njalo ngomalana nodaba lwaba-colonel Stale lathi khona ke kodwa khona ke ukukhuluma phakathi kwabantu ababili kade kusenzeka lapho ke futhi amahlandlo amabili ke lapho ke futhi ihlandlo lokuqala noma isikhathi sokuqala kungelanga la nge-2 zaka-August ngomnyaka 2014 bese ke ilanga lesibili ke lapho ke kade kuyilanga la nge-15 zaka-October ngomnyaka 2014 ke lapho ke yonkana le mininingwane iyona ke ngaphansi lapho ke noma unkulumo yabo ke kade khona ke ngaphansi kwe-page 23 la Colonel Stale ngaphansi kuyafidavit kade ayibhalile ewela ngaphansi kuka-exhibit O futhi washo khona njalo ihlangothi ithimba lakhe lapho ke noma into kade ithimba leziphoyisa kade lenza ke lapho ke ukuthi ixhumanise ke abantu laba bonkana futhi ke phecelezi nodaba lenkulumo iqhamuka kuhlangothi lwezombuso ke lapho ke ukuthi waqhamukise ukuthi kade khona ke inkulumo kade khona phakathi kwalabantu bonkana noma lo muntu kade aqashile ke abantu labake futhi nomsola wesihlanu ke lapho ke futhi nabanye ke abanye kade besebenzisana yena naye ke umsola wesihlanu ke lapho ke umsola oqala kuze kufince kumsola wesine ke lapho ke ekuthizeni baphumelelise lokubulala lokho.
In fact, the Section 205 records from Vodacom depicts a different scenario with regards to the communication that Colonel Stale testified about. It details that, in fact, Ms. Kelly Khumalo with the number 278270444358 had received calls from Mr. Arthur Mthokosiziseni and the deceased on the 2nd of August 2014 and 15 October 2014, respectively. The evidence of Ms. Pinky Vitilingam. I submit, my Lord, that there were discrepancies between the analysis of Section 205 records analyzed by Colonel Stale from the central database of the South African Police Service and the extracts of the Section 205 records, that is Exhibit JJ1. Ms. Pinky Vitilingam could not give an account of such discrepancies. She could only state that she could only testify about the Section 205 records from Vodacom, which depicted, as I've said earlier, my Lord, the communication on the 2nd of August 2014 and 15 October 2014 between Mr. Arthur Mthokosiziseni and the deceased Mr. Senzo Meyiwa to Ms. Kelly Khumalo. The data cell phone records do not disclose such communication between Ms. Kelly Khumalo and accused number 5 before this court. The SMSs between Ms. Kelly Khumalo and her sister Zandile Khumalo that reveal the following. In this regard, see page 6 to 12 of Exhibit 01. The trial commenced through the witnesses' evidence who were inside the house when the incident occurred, painting a picture of the robbery gone wrong. But when the trial progressed, it built around the assassination of the deceased. Brigadier Gininda described Ms. Kelly Khumalo as the mastermind and the trigger point in the execution of the deceased murder. And to that extent, he, Brigadier Gininda, applied for a warrant of arrest against Ms. Kelly Khumalo, which was never executed, as he says it was a prosecutorial-driven investigation. I'm well aware, my lord, that the state is not bound by the summary of substantial facts, which means that the evidence not disclosed therein or which differs from it will not be inadmissible on that ground alone. In this regard, see State versus Van Vuren at page 21, paragraph D to F. The court will nevertheless, in the evaluation of the state case, compare the evidence given with what the state indicated its case will be. See State versus Holoko, 1991, volume 2, SACR 203, capital letter A in bracket, at page 207, paragraph B to C. It follows that it is therefore crucial for the state case to indicate that the accused entered into an alleged conspiracy agreement with Ms. Kelly Kumalo. Failing such proof, the accused, that is accused number 4, cannot be convicted on any of the first 3 counts against him, and accordingly not on the 4th or 5th count.
Labe kasho khona njalo ukuphiceleza nodaba laloko lofakazi kade kuhamba lethu umama lapho ke uPinki vithi high lathi khona ke njalo khona ke kade khona ke pheceleza udaba lwezomthetho lapho ka section 204 kade khona ke lapho ke okungahambi kahle futhi amaphutha amaningi ke lapho ke pheceleza udaba lakwamnumzana Colonel Steele umqhathanisa lona ke nodaba loqhamuka lapho ngaphansi ku Vodacom usho ukuthi uColonel Steele nako uqhamuka ngaphansi kwe database noma wasebenzisa lapho ke I database ezesiphoyisa ke ngesikhathi kade senza lokho ke wacapha kuyona ke section 205 ke yakhe ke lapho ke bathi kokhona ke kwimibukiso lapho ke ka exhibit J1 futhi nalena kaPinki ke lapho ukuthi kade noma kade bengakhulumeli ke ngayo ke lapho ke la bathi khona ke kade ngakho ke ilukuzana data cell phone record lapho ke esho khona njalo kade khona ke inkulumo phakathi koKhili Khumalo ke lapho ke nomsola wesihlanu ke lapho ke athi futhi noma ngakho futhi idaba lama SMS ke lapho ke kade khona phakathi koKhili Khumalo nosisi wakhe lapho uZandi Khumalo oliqhamukile lapho ke futhi washo khona njalo kumele sibuke lapho ke ngaphansi kwesikhasi lesithupha kuyifince kwesikhasi le12 ke lapho ke ngaphansi kwemibukiso ke lapho ke ka exhibit 01 lapho ke futhi ngesikhathi athi ngesikhathi icala leli ke noma ngesikhathi icala behlezi likhulunywa phambi kungasenkantolo lapho ke athi khona ke kwade khona ke abantu kade khona ngaphakathi kwala muzi ke lapho ke futhi bona abantu bayisithombe ke khona ke lapho ke basho khona njalo ukuthi khona ke abantu kade befikile lapho ke bobamba ke inkunzi ke kepha kwakazi igcine kube sekubanjwa ke inkunzi ke lapho ke kepha gcina sebahlasela futhi bagcina bebulala ke khona ke lapho ke umufi ke lapho ke futhi athi uBrigadier Gininda naye uyena uchazile kabanzi lapho ke athi uKhili Khumalo uyena ke umastermind ukuthi yena ke umuntu odlala ke isikhangiso sokuthi lelokozana ke usuthi uyena kade ekhona phakathi nendawo ngesikhathi kade senzeka lokhu phakathi kwabasola futhi nomufi ke lapho ke bathi uBrigadier Gininda washo ukuthi kukhona ke incwadi kade ecelile lapho ke noma isicelo sencwadi kade asenza lapho ke ukuthi lapho koKhili Khumalo nake aboshwe ke lapho ke kepha lokho bathi akaze kwenzeke ke ngoba impilo yakhe ukuthi lapho ke ngesikhathi bekasesha icala leli futhi bekasebenzisana ke nethimba labashushisi ke lapho ke futhi iqhubeka washo khona njalo malana nesummary yakhe lapho ke ummeli wenu ke kade akhuluma ngalo yofakazi umhlaba ufakazi athi bukhona ke lapho ke wathi lokhu futhi into engekho futhi nanoma ekhuluma ngayo futhi ke wabuya futhi waqhathanisa phakathi icala leka Van Vuren lapho ke ekhuluma ngaphansi komugqa wesi21 noma ngaphansi kwekhasi lesi21 iqala paragraph D2F lapho ke akhulume khona njalo futhi nangelinye icala lombuso ngesikhathi umbuso ubhekene icala la kaHoloho lapho ke la ka 1991 volume 2 SCR 203 lapho ke yakhuluma futhi nangolunye ke udaba ke lapho ke futhi ubuyile wakhuluma khona njalo ukuthi lapho ke lokhu akukho la ithimba labashushisi noma ithimba lozombuso ke noma ihlangothi lozombuso la iqhamuke khona ke nenkulumo khona ke phakathi kwabantu labo ke futhi abasolwa ke lapho noma inkulumo eqhamukile ekusho ukuthi iyona ke vele ebambekayo nesihlahla futhi nomsindo ke lapho ke abathi la bathi khona ke umsola abasola bonkana futhi noKhili Khumalo kade bekhuluma khona ke bonkana bephelele ke futhi asho khona nje umsola lapho ke akangabekwa ke amacala ngalokhu konke ke akwenzile ke noma lokhu abamthwesa ukuthi ukwenzile engakwenzanga futhi amacala wonkana omathathu futhi necala lesine futhi icala lesihlanu.
The legal position I've referred to the provision of Section 174 of the Act. The corollary is that he ought to be acquitted. That is the accused, if it is reasonably possible, true that he might be innocent. My own emphasis. The word no evidence in Section 174 of the Act means no evidence upon which a reasonable person might convict the accused, as stated by Ramsey J. Instead versus Kanyapa, 1979, Volume 1, SA 824, capital letter A in brackets, at page 834, paragraph F. It is well established that no evidence does not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. The question whether a court should grant a discharge at this stage is one which entails a discretion by the trial court. It is a discretion which must self-evidently be exercised judicially.
Ngaphansi kwezomthetho-ke lapho-ke la ekhuluma phecelezi nodaba luka-section 174 lapho isicelo lesathi aqhamuke ngaso-ke lapho-ke lathi khona ekugcineni kwecala lezombuso-ke lapho-ke kwamele ukuthi khona-ke njalo lapho-ke uma ngabe-ke abantu bebona ukuthi kanjalo abanalo icala phecelezi nabo kwamele balethe isicelo lesi-ke lapho-ke athi futhi kwamele ukuthi inkantolo uma ibabona bengenalo icala kwamele ukuthi badedele-ke ngoshwele-ke lapho noma ibadedele nje kuphela-ke lapho-ke wathi washo khona njalo lapho-ke nanoma kusho lokhu-ke athi ngaphansi kwezomthetho zika-section 174 lokhu akusho ukuthi ubufakazi lapho-ke abukho-ke lapho-ke ubufakazi obukhethekile ubufakazi obubambekayo lapho-ke obungaze buphoqelele ekuthizeni-ke abasuke bagcine lapho-ke bethuswa-ke icala-ke lapho-ke futhi buyaqhathanisa phakathi icala lapho lika-Ramf CJ futhi libhekene necala lezombuso-ke lapho-ke noma icala likaKhanyapa laka-1979 SACR SA 824 lapho-ke A futhi washo khona njalo lapho-ke kwamele lokhu kubhekwe futhi kubhekisiswe kahle-ke lapho-ke uma ngabe ufakazi lokhu kade ufakazi obukhethekile mhlawumbe ufakazi obubambekayo noma ufakazi obubambekayo obunesihlandla noma ufakazi obunomsindo lapho bungekho khona-ke kwamele ukuthi lapho inkosi yenkantolo mhlawumbe inkantolo lokho isebenze ngendlela ekhethekile futhi ngendlela ejulile lapho thizeni-ke idedele-ke abantu-ke lapho-ke kumacala kade bathusa wona-ke.
The judicial pronouncement on the manner in which the trial court must exercise its discretion has been contentious. I do not intend to give a full historical overview. I will confine myself to a brief reference to those cases that help to define the scope of the court's discretion in terms of Section 174. In State versus Shopping and others, 1983, Volume 2, SA 119, capital letter B in bracket. IMSTRA CJ reviewed the case law history of discharge application and formulated the test as follows at 120 to 121, capital letter A. And I quote, at the close of the state case when a discharge is considered, the first question is Roman figure 1. Is there evidence on which a reasonable person might convict? If not, Roman figure 2. Is there a reasonable possibility that the defense evidence might supplement the state case? If the answer to either question is yes, there should be no discharge and the accused should be placed on his defense. Close quotation. There is criticism in respect of the second test in the Shopping case, and the criticism labeled was referred to in State versus Lubaka 2001, Volume 2, SACR 702 SCA inter alia, as follows. At paragraph 14, the criticism of Shopping's case relates to the second leg of the inquiry, which permits an accused person to be placed on his defense, even when there is no case to answer, merely in the expectation that the defense evidence might supplement the prosecution's case. To place the accused on his defense in those circumstances has usually been said to be in conflict with the presumption of innocence. Close quotation.
Lapho-ke phakathi kwelinye ke icala selahlalela ngaphansi kwenkosi enkantolo ke lapho ke le cala kade akukhuluma ke ngalo ke lapho ke la shopping futhi nabanye ke lapho ke kahle lapho ke M3 uthi ijudge yakhona ke lapho ke nkulumnkosi enkantolo ke lapho ke lathi khona eceleni kwecala noma qhathanisa phakathi kwesicelo sakhe lesi futhi nesicelo secala leli eda ke khuluma ke ngalo ke qala.
In State versus Lubata 2001, Volume 2, SACR 703 SCA, the following was said. The right to be discharged at that stage of the trial does not necessarily arise, in my view, from consideration relating to the burden of proof or its concomitant, the presumption of innocence, or the right to silence, or the right not to testify, but arguably from the consideration that more general application. Clearly, a person ought not to be prosecuted in the absence of a minimum of evidence upon which he might be convicted, merely in the expectation that at some stage he might incriminate himself. That is recognized by the common law principles, that there should be a reasonable and probable cause to believe that the accused is guilty of an offense before a prosecution is initiated. See Beckenstrater versus Rota and Tiernesen, 1955, Volume 1, SA 129, capital letter A in bracket, at page 135, paragraph C to E. And the constitutional protection afforded to dignity and personal freedom in terms of Section 10 and 12 of the Constitution seems to reinforce it. It ought to follow that if the prosecution is not to be commenced without that minimum of evidence, so too should it is when the evidence finally falls below that threshold. That is preeminently to be so where the prosecution has exhausted the evidence and the conviction is no longer possible except by self-incrimination. A fair trial, in my view, will at that stage be stopped, for it threatens thereafter to infringe other constitutional rights protected by Section 10 and Section 12 of the Constitution, close quotation.
Qhathanisa phakathi kwecala lapho ke likambuso futhi icala likalubaqa ke lapho icala lango 2001 ngaphansi usuthi volume 2 lapho ke SACR 703 lapho icala ka inter ali lapho ke bayakhuluma phecelezi ngodaba lolu ke lesicelo sakhe sokuthizeni abasolo babadedeleke noma umsolo abadedeleke lapho ke bangamthwesa icala ngaphansi kuwonkana amacala ade bemthwesa wona ke lapho ke yilokhu nje kuphela kade kubalekile bekakhuluma ngakho uqhathanisa phakathi icala leliyana eselahlala ngaphambi kwenkosi enkantolo ngesikhathi nesindlule futhi icala lelakho lamanje.
It has been held that the credibility of state witnesses at this stage of the proceedings only play a very limited role. In State versus Mpeta and others, 1983, Volume 4, SA 262, capital letter C at 265 D to G, Williamson J. held that relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. Close quotation. Therefore, to summarize the legal position regarding application in terms of Section 174 is as follows. An accused person is entitled to be discharged at the close of the case for the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. B. Credibility of witnesses' evidence is only in issue where it has been the effect that the evidence is so unreliable that it can be said that no evidence has been adduced. C. Where the evidence of the state witnesses indicating the accused is of such poor quality that it cannot be relied on, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, an application for a discharge should be granted. D. An acquittal must be in the interest of justice. E. Circumstantial evidence in the state case may be relevant factor in deciding whether a case against the accused is so strong that it calls for a reply in the witness stand. It is against this legal background that I find it prudent to refer to the portions of the evidence of Zungu in the record of the proceedings and later proceed to analyze his evidence. Constable Sizwe Sikumbuzo Zungu testified that he was a constable employed by the South African Police Services with 12 years experience under the invisible policing station at Sebenza Police Station. He knows all the accused before court. He knew Mthokosiziseni accused number 4. He remembers him from Phosphorus, but not back home. On the 26th of October 2014, he received a call from Gwabeni. Gwabeni wanted to know him, from him, that is Zungu, whether he was able to come to Phosphorus on that day. He responded that it was still early because it was around 7:15, and that on that day he was still going to work. Gwabeni called him again and informed him that there was another brother of ours, Makosonke from Rustenburg. He informed him that Makosonke was also going to be joining us. He knocked off and contacted Makosonke Zungu. He informed him that he was at Johannesburg at Carlton Center. That is where he will find him. He went there and found him. They arrived at a hostel between 2 to 3. He will not be able to remember the exact time.
Lapho ke afunda phecelezi nodaba lolu-ke futhi washo khona njalo uma ibuka lapho icala lapho-ke lezombuso kade lapho lihlelwe inkosi yenkantolo lapho-ke uHomu-ke lapho-ke futhi icala lezombuso phakathi no-Aglito lango-2011 volume 2 lapho-ke CCR 437 lapho-ke beyakhuluma phecelezi nodaba lolu-ke lokuthi khona-ke lapho-ke uma ngabe icala seliphethe ifike emaphethelweni-ke lapho icala lezombuso-ke lapho-ke uma ngabe-ke umswa lapho-ke ngafisa ukwenza lokhu okulandelayo ngaphansi kwezomthetho-ke unakho ukuthi akwenzeke lo sicelo sesikhethekile lapho-ke lathi khona-ke umsola khona-ke njalo uvumelekile futhi unakho ukwenza lokhu-ke egcineni kwecala lezombuso lapho-ke ekuthizeni aqhamukise nesicelo sakhe lapho-ke noma mhlawumbe ayabiza abofakazi bakhe-ke lapho-ke noma ngene ngaphakathi kwebhokisi lapho-ke bese ayikhulumele noma mhlawumbe-ke lapho-ke azifake yena-ke mathupha-ke ecaleni-ke lapho-ke athi lapho-ke uma ngabe sibuka futhi bofakazi ade bekhona-ke lapho-ke uma bengenaso isihlahla mhlawumbe isihlahla msindo lapho-ke kwamele ukuthi abasola lapho babadedele bababone futhi bengenacala lapho-ke wathi lokhu kukhona wathi lokhu kukhona uma buka phaka icala lapho-ke lakambuso futhi noSwartz lapho-ke lango-1999 volume 1 lapho-ke CCR 319 lapho-ke open bracket besathi W lapho-ke noma ukuthi lapho ufakazi bezombuso lapho-ke nomhlaba noma ufakazi noma abofakazi bezombuso lapho uma belethe ufakazi obungenasihlahla msindo noma ufakazi lapho mhlawumbe-ke obungahambisani-ke lapho-ke noma ufakazi lapho mhlawumbe obuphuwa-ke lapho-ke obungenayo lapho-ke isihlahla msindo okubonayo-ke lapho ufakazi obumayelana nalolu daba lolu-ke athi kwamele inkosi yenkantolo lapho-ke ingagwebiki abasolwa noma engabathuli-ke abasolwa benicala lapho-ke kwamele futhi ekuthizeni ibavumele uma ngabe sebeletha isicelo sabo sokuthi babadedele ngaphansi kwamacala wonke akade bebathusa wona-ke lapho-ke wathi ku-D lapho-ke usho ukuthi lapho lokhu kwamele ukuthi bakwenze ngaphansi kwezomthetho noma ngaphansi kwezamalungelo ezomthetho-ke lapho-ke futhi wabuya wathi washo khona njalo-ke lapho-ke wathi mina nofakazi bethimba lwezombuso loba abathi bona-ke banabo lapho-ke kwamele ukuthi inkosi yenkantolo futhi ibukisise futhi ibuke ngendlela ekhethekile futhi ngendlela-ke ejwayelekile engabuke ngendlela engajwayelekanga abofakazi lapho-ke kade bekhona-ke lapho-ke bese qhathanisa phakathi kwecala lezombuso-ke lapho-ke nocele lango-1986 volume 2 PHH 121 futhi washo khona njalo lapho-ke uma ngase sikwapha ku-background-ke lapho-ke sithi abofakazi ade bekhona-ke lapho-ke bathi khona-ke ufakazi othizeni-ke lapho-ke okade bukhona ufakazi bakhe okade ekhona ngaphambi kwinkosi yenkantolo-ke lapho-ke bese washicelela ufakazi bakhe lapho-ke bathi uZungu bathi khona kwinto ekhuluma ngaphakathi kwenkosi yenkantolo-ke ngesikhathi bekalana-ke washo khona njalo yena-ke uconstable Sizwe Sikhumbuzo Zungu-ke lapho-ke ngesikhathi bekathula ufakazi bakhe-ke lapho-ke washo uconstable futhi usebenza ngaphansi kwezesiphoyisa-ke wathi uneminyaka-ke 12-ke esipiliyoni esebenza ngaphansi kwezesiphoyisa-ke futhi usebenza usebenza ngaphansi kwesiphoyisa sasesebenza police station ke lapho ke futhi washo yena ukuthi bonkana abasola uyabazi labantu khona ngaphambi kwesenkantolo ke futhi wathina uMthokoziseni wamazi njengomsola wesine ke lapho ke ngesikhathi beqala kumona eFosforus ke kepha kana umkhumbulo wakhe wasemakhaya ke athi ngelanga lenge-26 October ngaka 2014 akathola ucingo kade liqhamuka kogwabeni bathi ugwabeni uyena ke owazisa ke uzungu noma watshala ke uzungu okuwukuthi kwamele ukuthi afike eFosforus ngalo ke lelalanga lelo ke bese uzungu waphindwa wathena ke wabamshayela ngesikhathi sakusasa samahora kusasa ke athi nge 7:15 yakusasa ke lapho ke yena futhi bekazokuselela kuya emsebenzini ngesikhathi bekashayela lapho ke bathi ugwabeni ke nawe yena ke wamtshela khona njalo ukuthi khona ke umunye umfowabo ke lapho ke noma umfowabo lapho ke kade kwabathi uMakhosonke ke maqhamuka ngaphansi noma kade aqhamuka ke Rustenburg ke uMakhosonke lapho ke bathi wamtshela ukuthi uMakhosonke khona ke naye futhi uzofika abajoyineke noma hlanganele nabo endaweni eyodwana ke lapho ke bathi yena ke washayisa ke emsebenzini ngesikhathi beshayisa emsebenzini ke bese qwathinta ke uMakhosonke ke lezungu ke lapho ke wamtshela ukuthi kumele bahlangana lapho ke eGoli eduze Carton Center noma eCarton Center ke lapho ke athi yona ndawo bekazomfica kuyo ke ngeleyo ke uma ngabe sekashayisile emsebenzini ke athi empeleni ngiqiniso ogcina befika ke lapho ke hostel ngemuva kwehora lesibili noma ngehora lesithathu kade engasakhumbuli kahlehle ukuthi ngabe wafika ngasiphi isikhathi lapho ke.
It is against this background that I will proceed and analyze Zungu's evidence. According to the version of the state, the only witness who met and placed the accused at Phosphorus Hostel on the 26th of October 2014 was Constable Zungu, Constable Sizwe Skhumbuzo Zungu, who was a single witness. It is straight law that a court should approach the evidence of a single witness with caution. The following passage from the judgment of the Phyllis JP in R. vs. Mokoena 1932 OPD 79 at page 80 is frequently cited. I quote, "The uncorroborated evidence of a single competent and credible witness is no doubt declared to be sufficient for a conviction. But Section 284 of Act 31 of 1917, that is the predecessor to Section to the Act 51 of 1977. But in my opinion, that section should only be relied on where the evidence of a single witness is clear and satisfactory in all material respects." Close quotation. Instead versus Weber, 1971, Volume 3, SA 754, capital letter A in bracket, the appellate division stressed that there was no magic formula which determines when the evidence of a single witness testimony may warrant a conviction in every case. What may be said, however, is that the evidence of a single witness has to be approached with caution. His or her merits as a witness must be weighed against factors which militate against his or her credibility. Thus, the mere fact that he or she has an interest or bias against the accused will not of itself obviate a conviction. It is necessary to assess the intensity of the bias in the light of the totality of the evidence. Close quotation.
Ufakazi oyedwa ke ufakazi kodwa mhlambe usuthi ixhuma lezombuso esithi abahambisana ufakazi babo ke futhi ibona ke uyena ufakazi oyedwa kuphela lona ke kade ubeka kabasolwa ngaphansi kwendawo seFosphorus lapho ke wathi ufakazi lo ke uConstable Sizwe Skhumbuzo Zungu ke owasho ngathi mina ke kade likhona ke lapho ke lokuzana lapho ke ke futhi ubuye washo khona ngathi ethimba lozombuso futhi nenkantolo ke lapho ke akumele ukuthi lapho ke uma sebuka kufakazi babuke kufakazi bofakazi oyedwa ke osho ufakazi oyedwa ke loyo ke osuke esikhathini esiningi ke ebeka ke labantu abasola ke ngaphansi kwendawo esigameko ke noma ngaphansi kwendawo khethekile noma ngaphansi kwendawo ethizini ke lapho ke ngoba bathi lokho esikhathini esiningi usuke akwenza ngokuthi ke mhlambe unento ke mhlambe shuthi mhlambe angayithandile kubona mhlambe engahambisani ke nabo ke noma mhlambe eyenza lokho ekwenza lokhu ke ngokuthi ufuna ukuthi abantu abashuthi mhlambe abacekela phansi ke lapho ke noma futhi bababoneke benecala ke abantu labo ke bathi kusenkantolo kwamele lokho kubuke futhi ngendlela ke ekhethekile futhi ngendlela ke ejulile.
Corroboration. In State vs. Gently 2005, Volume 1, in bracket SACR 420 at 430, QTJA in dealing with the approach to be followed by a court when it is faced with a situation where a court should caution itself in analyzing the evidence said the following, I quote, It must be emphasized immediately that by corroboration is meant other evidence which support the evidence of the complainant and which renders the evidence of the accused less probable on the issue in dispute, close quotation. It is clear from the authorities that if corroboration was required, if it had, for purposes of the so-called cautionary rule, to be corroboration implicating the accused and not merely corroboration in a material respect or respects. The evidence of Zungu was not corroborated in all material respects. Skhumbuzo Zungu was not called by the state to corroborate the version of Zungu, insofar as traveling with Zungu to the hostel after he had received a call from Gwabeni to pick up Skhumbuzo Zungu at Cotton Center in Johannesburg. Zungu is the only witness who met the accused at Fosora's hostel. He was introduced to the accused by Gwabeni. It is surprising that this introduction was done to this witness when Zungu and the accused knew each other. Zungu testified that he was requested by a certain gentleman, that is accused number 5, was requesting him to remove his vehicle because he had parked behind the vehicle that accused number 5 was traveling. Zungu and others he was seated with went to buy liquor and they drove using an Uno motor vehicle. He was traveling with accused 2, accused 3, and the driver. There were 5 in total. From the body of Zungu's evidence, this is the only time that he had traveled with accused 2 and accused number 3.
Lapho futhi kade afunda khona ke phansi but ufakazi lokho kade buhambisana ke lapho ke athi lokho sibuka ngaphansi uma eqhathanisa kumacala ke lapho ke icala lapho ke lozombuso ke libhekene icala lapho lika Gentile nga 2005 ke lapho ke volume 1 ACCR 420 ke lapho ke futhi ngaphansi ko 430 ke lapho ke futhi inkosi enkantolo lapho kade ku include JA lapho ke athi ngesikhathi kade kusenzeka lokho ke ushuthi noma eqhathanisa ke lapho ke athi inkosi inkantolo kwamele lokho ikubukisise ngendlela eqondile futhi ngendlela ekhethekile ke lobu lofakazi obulandelayo ke noma mhlambe ebufakazi obulandelayo labo ke lapho khona ke kwamele ukuthi lokho bakwenze benze iqinisekiso ubufakazi labo buyahambisana bonkana futhi bonkana nofakazi babantu ade bevule icala lapho ke beyahambisana nofakazi bonkana babufakazi esube bezolothwa ngaphambi kwenkosi enkantolo lapho ke besathi ummeli lapho ke uma isefika lapho ku 14.2 lapho ke athi cace bha ukuthi lapho ke lokho akaze kwenziwe ke lapho ke noma kade akwenziwe ngendlela ekhethekile lapho ke ngoma uma sekhona lapho ngecautionary rule ke lapho ke somthetho okhethekile lapho ke ubufakazi okushuthi lapho obuquka khona ke abasola bonkana noma bafaka ngaphathi abasola
So mention, I must also at some point, I also at some point went out to the shops to buy some alcohol and drinks with a certain lady and came back to Kwabene's house. Close quotation. It is clear that Zungu does not place the accused, that is accused number 4, traveling together using the VW Polo hatchback grey in color that he alleged accused number 5 was using, leaving the hostel, and part of his evidence is that he saw accused 1, 2, and 3 coming in, following each other, going towards Kwabene's room, and he followed them. Inside the room, accused 1 was in possession of a .38 special revolver, and accused number 3 was in possession of a 9mm pistol. Accused 5 came inside the room. He was followed by accused number 4. Zungu states the following at page 2, paragraph 5, line 1 to 3 of his affidavit, and I quote, "Around 9 p.m. on the very same day, I noticed Moses Spear Mafiga, open bracket, Sandy Sontanzi, close bracket, and Kani, open brackets, Fisokuhle Zungu Ntuli, close bracket, walking after each other to Kwabene's bedroom from outside. It does not mention accused number 4, following accused number 5 to Kwabene's room. At page 2 of his affidavit, paragraph 5, line 6 to 9, he states the following, and I quote, "I saw Moses giving Kwabene a .88 special firearm and Kani giving Kwabene a 9mm firearm," close quotation. At page 2 of his affidavit, paragraph 5, line 20 to 21, he states the following, and I quote, "Mthokosiziseni Maphisa and Carlos Ngube walked into the bedroom and sat on the bed," close quotation. There are material contradictions between Zungu's evidence in chief and his written statement. The correct approach to any contradiction between the prior statement and the witness's testimony was, in respect, most useful, summarized by Olifield J.A. Instead versus Mafala Diso in another, 2003, Volume 1, SACR 583 SCA. The head notes in that case is submitted accurately, reflected, was said and was cited by Nechben J. Instead versus Governor and another, 2006, Volume 1, SACR 322, capital letter E in bracket. In respect of the factual evidence of Zungu's evidence, the contradictions are material and affect his credibility. During cross-examination by Mr. Ramsepel in respect of Zungu knowing accused 2, this is how Zungu responded, and I quote Mr. Ramsepel. "Now, accused number 2, because I will chop and change with respect to accused 1 and 2, but accused 2 himself says he does not know you in total. He just see you here yesterday in court, Mr. Zungu. If that was said or was coming from accused 3, 4, and 5, I would have agreed with you. Okay, where I was born or back home, where I was born, or he is Ndanzi. It is clear from Mr. Zungu's evidence, when question is posed to him by Mr. Ramsepele in respect of him knowing accused number 2, his response was that if that was said by accused 3, 4, and 5, that they do not know him in total, he was going to agree. The response by Zungu is a clear indication that he did not know accused 4, in the light of the fact that he says he was going to admit that he did not know accused 4 if such assertion was put to him by accused number 4. During cross-examination, Zungu testified that a typed version of his statement was made out of notes that he had written himself. And where there are contradictions in paragraph 5, he actually meant accused 4 and 5 entered Kwabene's room and not accused 3. During cross-examination by Mr. Ramsepele about Zungu mentioning in his written statement that he went to Top Spa to buy liquor in the company of a lady, this is how Zungu responded. Mr. Zungu, I think it is a matter I think maybe it is a manner in which it is put here, but I did go to talks with the gentleman. We came back and then there is a lady that just want to go nearby who had requested me to buy her a drink, and I did go out with that lady. In his evidence in chief, Zungu testified that the person wearing a cap was accused number 2 when he was confronted that in fact the person wearing a cap was accused number 4. He could not proffer any explanation. Zungu testified that at some point he met Brigadier Lishabane, who informed him that he was going to conduct his own investigations, and thereafter he would come back and inform him, but did not tell General Lishabane that he was at a hostel. The reason was that he did not want to give General Lishabane this information, that it was coming from him, and that he did not have certainty with regard to that. Clearly, Zungu had an axe to grind for the accused when one considers the compactness of his evidence. Zungu testified further that on the 13th of November 2013, he had a meeting with Brigadier Gininda. Brigadier Gininda asked him what he knew about the killing of Senzo Meyiwa. He told Brigadier that he knew nothing and there was nothing that he can talk about. Brigadier Gininda told him that he was going to do his own investigations. At that meeting, Brigadier Gininda was with Brigadier Tony. Zungu testified that the relatives had to shoot him. He spoke to accused number 1 over the phone and asked accused number 1 why his relative wanted to shoot him, because he, Zungu, also did not know anything about this matter and did not know anything. It is clear, my lord, that from the responses or the evidence of Zungu, he mentions that not even on one occasion that he did not know anything about this case. He said this in the presence of General Lishabane. And on the 13th of November, when he had a meeting with Brigadier Gininda, he repeated the very same assertions that he did not know anything or knew nothing about the killing of the deceased. Thirdly, he mentioned this when he spoke, as you say, to accused number 1, when he was making inquiries about why his relative wanted to kill him, because he did not know anything about this case. Further, to proceed, Zungu could not explain what was the occasion on page, I'll come back to that, of Exhibit C, despite claiming that he was with accused 3 and 4 on the day of that occasion, the date of the 26th of October, 2014.
But you are saying Zungu's evidence is not corroborated in any of the evidence led in this court?
Yes,
Never.
never.
Remember, what's the time they say?
It's 11, my lord.
Yeah, well. You remember there was evidence by Buthelezi, a gentleman called Buthelezi, who went to see accused number 1 to give him some washing items. Sorry, number 2, yeah, you're right. In Rustenburg, next to some supermarket there.
Yes, I remember that evidence, my lord, very well.
Yeah. And then there's another piece of evidence, I think I was accused number 1, who was drinking Irish whiskey and exclaimed that Senzo is no more, Senzo is no more. You don't remember that?
I remember that.
Okay, on that note, let's go and have a drink.
Notable la 16 paragraph 16 14.6 la malana present notable affidavit lapho ke kade khona kamnumzana ke uZungu wayikhuluma ke lapho ke athina ke kwesinye isikhathi kade angekho kwesinye isikhathi usele waphuma wahamba wayake ezitolo futhi ngesikhathi beka ezitolo thinga ke utshwala bokuphuza ke lapho ke bebathi bekahamba khona ke lapho ke bephelekezwa wesimame mhlawumbe yebo wesimame ke bese ngemuva kwalokho babuyela ngaphakathi kulamuzo kwaGwabeni ke lapho ke athi ucaceba uthina ke uZungu ngesikhathi ade senza lokho ke lapho ke kade engakhulumile ukuthi lapho ke abasolo ade behamba ngemoto ade ku VW Polo hatchback enombala ke ugreen kombala ogqamile ke lapho ke futhi ukuthi le moto ke ade kumuntu kamsola wesihlanu ke lapho ke futhi ngesikhathi ade bephume hostel basebenzana ke imoto leyo ke ngesikhathi behamba ke lapho ke athi wabona akakaza asho ukuthi wena lapho wabona umsolo oqala wesibili nowesithathu ke lapho ke besala nemuva belandelana lapho ke bengena ngaphakathi komuzi kaGwabeni ke lapho ke futhi ngesikhathi bengaphakathi kwalamuzo kwaGwabeni ke lapho ke athi umsolo oqala futhi nomsolo wesithathu umsolo oqala baphethe ke isibhamu lapho ke i38 special revolver lapho bese umsolo wesithathu ke nake bese baphethe ke lapho isibhamu se9mm pistol lapho ke athi umsolo wesihlanu ke yena ke wahamba wangena ke ngemuva elandelana nomsolo wesine ke lapho ke bathi uZungu yena ke udaba futhi waphinda ukukhuluma lapho ke ngaphansi kwekhasi lesibili ke lapho ke kumugqa paragraph 5 kumugqa oqala kufince kumugqa wesithathu ke lapho ke ukuthi lapho ke malana nesikhathi sehora la ka9 ke lapho ke ngalo lelo langa lelo ke athi into awayiqapha ke lapho ke ukuthi umuzi Sibiya umafika futhi bese kuma bracket bathi Sandi Sontanzi ke lapho ke bathi futhi nonkani uSifiso Zungu Ntuli kade behamba belisana emuva besiya ngaphakathi kule gumbi yokulala ke lapho ke kade lekhona ke kulomuzi kade khona ke ngaphandle ke lapho ke futhi akaza asho ukuthi wona umsolo wesine kade akhona ke ebasele emuva nomsolo wesihlanu ke kuze behamba bengena ngaphakathi kulela kamura lelo ke bathi futhi waphinda ukukhuluma khona njalo ke lapho ku page kukhasi lesi2 ke lapho ke kumugqa wesithupha kuze kufince kumugqa wes9 ke lapho ke lathi uZungu nakho khona ke njalo ngaphakathi kwaGwabeni ke lapho ke wabona lokhu umuzi wabona ke umuzi enikeza uGwabeni i38 special isibhamu ke lapho ke futhi unkani ke taphethe ke nake i9mm firearm ke lapho ke isibhamu ke lapho ke bathi khona njalo phinda ukukhuluma njalo ukuthi lapho Mthokosiziseni Maphisa futhi noCarlos Mncube bahamba fika bahlala ke lapho ke besanemuva hlala phezulu kombhedo ke lapho ke bathi khona ke njalo lokhu khona ke ungahambisana phakathi kwenkulumo yakhe ke kade ayikhuluma ngesikhathi lesibekalana phambi kwenkosi enkantolo ke uma kade ebuza imibuzo lapho umshushisi ke futhi umphecelezi nodaba lombuzo ke lapho ke noma nenkulumo yakhe kade ayibhalile ke lokho ngaphansi kwe-statement sakhe ukuthi khona ke izinto ade zingahambisana phakathi kwalokho ade akusho futhi lokho ade akushilo ngaphakathi kwe-statement sakhe bese wabuya futhi wakhuluma khona njalo ke lapho ke wacaphula phakathi kwenkulumo kade ibuzwa ke lapho ke umnumzana uRamsipili ke lapho ke phicezi nodaba la kwamnumzana ke lapho ke uZungu ke lapho lofakazi bakhe ke kade bungahambisana khona njalo ke la wathi khona kumnumzana bese wacaphula khona njalo ke bathi umnumzana uRamsipili uyasho khona manje ukuthi ke naye umsolo wesibili ke phake lapho uzothi ashintshe futhi asho ukuthi umsolo oqala futhi noma umsolo wesibili ke bathi uyasho khona ukuthi yena akakaze amboneke uZungu noma akakaze amuzungu ngaphambili futhi beqala kumbona ke enkantolo kwela ngendluleke lapho ke bathi uZungu khona ke nje lapho wathi yebo ke lokho uma ngabe kulokho uqhamuka kumsolo wesithathu ke nosine nosihlanu ke ngakuvuma ngihambisana nawe ke athi kepha ke umsolo la kundawo siqhamuka kuyona ke ekhaya noma la yena kwazalwa khona ke lapho ke bathi bambiza nje ukuthi uNtanzi ke loyo ke umuntu bese baqhubeka futhi inkulumo khona ke yasho khona njalo ke ukuthi uZungu waphendula phecelezi nodaba lwenkulumo ade ibuziwe lapho kumayana nomsolo wesine ke lapho ke ukuthi ngabe bekamazi noma kade angamazi yini ke lapho ke athena akakazi asho inkulumo eqondile ukuthi ngabe bekamazi noma kade angamazi ke lapho ke futhi yabuya futhi waqhubeka inkulumo yakhe ke yakhuluma ke lapho ke bathi uZungu ngesikhathi kade abuza ke imibuzo lapho ke abameli phecelezi nodaba lwenkulumo yakhe ke ehlukile engafani wayibhala ngaphansi kwe-statement sakhe ke lokhu ke bathi ke wakwenza wacacabha ukuthi yena ke lokhu ke akubhalile ke phansi ke nokade kungahambisani futhi kuyinkulumo engahambisani engaphansi kwa-paragraph 5 ke lapho ke bathi yena ke lapho kukhona ke yena ke bekathi bekazama ukusho khona ke njalo ke athi wenza ke iphutha lapho ke bekazama ukukhuluma umsolo wesine futhi umsolo wesihlanu ke ukuthi ibona ke bangena ngaphakathi kwelela gumbi la kamnumzana kuGwabeni ke kade ungasiyena ke umsolo wesithathu ke lapho ke bese wabuya futhi umnumzana uRamsipili wambuza futhi ke imibuzo ke ngesikhathi elana ke emphenya ke embuza ke imibuzo ke lapho ke mayelana mayelana nodaba lwakhe alukhulumileke ngaphansi kodaba noma lwenkulumo yakhe oyekade eyibhalile phansi lapho-ke isitatimende sakhe-ke ukuthi bona-ke bahamba bayahake lapho kwindawo idesakhe utshwala kusho ukuthi lapho-ke tops espa lapho-ke ngesikhathi bekahamba ephelekezwa-ke usimameke uzungu-ke bathi nayicabanga waphendula ngokuthi-ke yebo ngiyacabanga ukuthi mhlawumbe-ke le ndlela abayisho ngayo-ke kepha nathi akakazi wathi ngesikhathi bekahamba-ke lapho-ke wahamba-ke nabesilisa-ke futhi nangesikhathi bekabuya-ke wathola sekukhona-ke owesimameke futhi owesimameke-ke uyena-ke wamceda amthengeleke lapho-ke utshwala-ke besathi yena-ke wahamba-ke wathenga-ke utshwala-ke lapho-ke bathi futhi inkulumo kaZungu kwayikhuluma futhi uma sebeqhathanisa phakathi kwenkulumo yakhe futhi bengahambisani-ke lapho-ke wakhuluma ngaphansi kwesifungo-ke langaphambi kwenkosi yenkantolo-ke kuwukuthi uZungu yena-ke wakhuluma mayelana phecelezi nomuntu bagqoke-ke lapho-ke i-cap-ke kuyena-ke kuthi umsolo wesibili-ke loyo-ke futhi wathi yena-ke umuntu wakhuluma naye futhi ngesikhathi sekubeka lapho-ke ukuthi bathi umsola wesine-ke uma seyabuye eshintsha inkulumo yakhe-ke lapho-ke bathi futhi uZungu khona-ke inkulumo ayikhuluma-ke ngaphambi kwephoyisa-ke elikhulu-ke lapho-ke bathi uMajor General Shabaneke okuwukuthi wamtshela ukuthi yena-ke akunalutho-ke alaziyo futhi usho ukuthi umnumzana uGeneral Shabaneke wamtshela ukuthi yena-ke lapho-ke uzohamba-ke enzeke ukusesha kwecala leli-ke lapho-ke bese ngemuva kwalokho abuye aze-ke yena-ke lapho-ke amtshele-ke bese yena-ke watshela-ke uGeneral Shabaneke ukuthi yena-ke akunalutho-ke ayaziyo futhi kade akekho-ke ehostele-ke lapho-ke futhi washo ukuthi izathu zezo ukuthi kungani-ke wakhuluma lokhu-ke kepha kwabuya futhi washintsha-ke inkulumo yakhe-ke lapho-ke uZungu-ke bathi khona kuZungu usho ukuthi ukhulumile ucace bha ukuthi na-ke uZungu-ke lokhu-ke kwenzeka ekuthizeni-ke acekele abasolwa phansi-ke bonkana lapho-ke ngesikhathi wakhuluma inkulumo yakhe lebengahambisani-ke bathi futhi uZungu wathi letha ufakazi bakhe-ke ngelanga lange-13 zakaNovemba ngomnyaka 2019-ke lapho-ke ngesikhathi bathi nomhlangano lapho-ke nobaba uBrigadier Gininda-ke lapho-ke futhi bathi wabuzwa-ke na ukuthi mhlawumbe yini ayaziyo ngokushona noma ngokubulawa kaSenzo Meyiwa-ke lapho-ke bathi na waqhubeka khona njalo washo njalo-ke uZungu ukuthi yena-ke akunalutho olaziyo mayelana nokushona kwalo muntu mhlawumbe nenkulumo lezi-ke bese watshela ukuthi ubaba uBrigadier Gininda-ke lapho-ke okuwukuthi yena-ke akunalutho futhi ayaziyo futhi akunalutho-ke athize wayenza-ke lapho-ke noma awazoyenza-ke lapho-ke bathi inkulumo uZungu wayekhuluma-ke lapho-ke futhi uma seyabuka futhi lapho-ke sebeqhubeka nenkulumo kaZungu-ke basho uZungu ukhulumile phecelezi nodaba lokuthi kufakazi bakhe-ke khona-ke umuntu wesibili-ke lapho-ke kade agqokile lapho-ke i-cap-ke yena-ke futhi nakule thombe lezo-ke kade akhona-ke futhi ngekhe asho khona njalo ukuthi kade kumsolo wesine noma kade ungasiyena umsolo wesine.
My Lord, by corroboration, I meant corroboration which implicate the accused in the commission of the offense. And there was nothing, absolutely nothing in the evidence of Zungu that implicated the accused in the commission of the offense. In fact, what Zungu testified about, he referred to not less than 5 people that he met on that day. Not people he met on that day. He referred to not less than 5 people in his evidence. And such people were not called as witnesses in this case. And on the transcribed record of the 7th of September 2023, on page 29, line 10 to 14, this is what the court said about such tendency of this witness Zungu to refer to hearsay evidence. And I quote, by court, just to place it on record that I will not entertain the hearsay, I'm not going to take it into consideration. Mr. Baloyi, as the court pleases, by court, all the hearsay, Mr. Baloyi, as the court pleases. So, the bulk of the evidence of Zungu refers to hearsay evidence in the sense that no witnesses were called before this court, despite him referring to those people who were called before this court to corroborate the evidence of Zungu. The other issue, my Lord, that I wish to address is the concerns which were raised by court that at some point, accused number 2, Bongani Ntanzi, met Jack Telezi. That is after the court appearance of Mr. Ntanzi, accused number 2, before this court. He refers to this is what Buthelezi says upon that meeting that transpired. He says Bongani Ntanzi said there was a party and that he said he was in the company of his friends. He said it was Maphisa and them when he referred to his friends. By Maphisa, it was never pursued through the evidence in chief to this witness by the state, my lord, to clarify to the witness which Maphisa was he referring to when he testified with reference to Maphisa that Mr. Ndanzi, accused number 2, had said he was with Maphisa at a certain party with his friends in Vosloorus. Zungu could not explain what occasion on page 47, 48 of Exhibit C, despite claiming that he was with accused number 3 and 4. In his evidence in chief, he testified the person wearing a cap was accused number 2, but when confronted that the person wearing a cap was in fact accused number 4, Mr. Maphisa, he retracted his earlier version and said he could not see accused number 4 in the picture. The common purpose doctrine. Instead versus Mawala, unreported case number AR267 of 2016, delivered on the 12th of October 2018, Pillage A at paragraph 19 said the following regarding the doctrine of common purpose. The court held that common purpose is a legal construct to assist the state in prosecution where evidence is insufficient to link offenders to one another and to the crime. It is evident that the principle of common purpose is not just a tool, but an effective mechanism created to serve justice. Without it, the state will have been clueless as to the true identity of the one who committed the act. The common purpose principle makes it easier to not just punish the true actor, but also to his co-conspirators who had the intention to commit such crimes that caused the unlawful results. Those quotation. Instead versus Mketezi, 1989 volume 1 essay 687, capital letter A in bracket at 705 I to 706 C, the court established that a person to be held liable for a crime committed under the doctrine of common purpose, where there is no evidence of prior agreement, the following criteria must be met. A, presence at the scene. The accused must have been present at the scene of the crime where the violence was being committed. B, awareness of the attack. The accused must have been aware that the criminal attack was taking place. C, intention to make common cause. The accused must have intended to make common cause with the other participants or other co-conspirators committing the assault. D, active association with the attack. The accused must have manifested his sharing of a common purpose by himself performing some acts of association with the conduct of the others. E, intention to kill the deceased or to contribute to his death. The accused must have had intention to kill the deceased or contribute to his death. In the light of the facts of this case, it is important to note that the common purpose doctrine, as exposed in State versus Mgedes and others, has been pronounced by the Constitutional Court to be constitutional. In State versus Tebas, the most critical requirement of active association is to keep too much a liability. Current jurisprudence premise on a proper application of State versus Mgedes and others makes it clear that 1, there must be a close proximity, in fact, between the conduct considered to be active association and the result. Roman figure 2, such active association must be significant and not limited participation removed from the actual execution of the crime. Zungu's evidence, which I submit, that is version and that of accused number 4, are mutually destructive. Zungu met accused 4 at a hostel. Gwabini introduced the accused to Zungu, despite Zungu knowing the accused. Zungu later met accused 4 after accused 1, 2, and 3 had entered Gwabeni's room. Accused 5 entered the room, followed by accused number 4. This is according to Zungu. After some time, he was going to his vehicle. He noticed that the vehicle keys were not with him. He went back and asked Gwabeni, where are the vehicle keys? And Gwabeni made a call to a person whom he thought was related to accused number 4. And he made a call to a person whom he referred as Mzala. And he thought that person was accused 5, did not answer the call. Zungu testified that accused 4 arrived and gave him the vehicle keys. According to Zungu, accused 4 showed his greatest fullness and clapped his hands together. Zungu's evidence, it must be noted, my lord, that it does not detail a plan by the accused to execute the assassination of the deceased. It does not place the accused together, or even himself, Zungu, that he overheard such a plan. Zungu's evidence does not reveal any prior agreement amongst the accused, including accused number 4, to kill the deceased. In the absence of a prior agreement to kill the deceased, it therefore becomes important to apply the 5 principles as stated in Gedde's decision. The presence at the scene. The accused must have been present at the scene of the crime where the violence was committed. There is absolutely no evidence, my lord, that accused number 4 was present at the scene of crime where the violence was being perpetrated, either circumstantial or direct, at or near the scene of crime at house number 135. My lord?
What about the confessions?
I'm still coming to confessions, my lord.
Oh, I see.
Yes.
Okay.
B.
That's amusing.
The issue of confessions, my lord.
And I'm not thinking what you're thinking.
No, I'm absolutely on different terrains.
Yeah, I can tell you what I'm thinking, not what you think I'm thinking.
All right, thank you.
Section 218
218.
and 217. What do they say?
217 is admissibility of a confession.
217 is about pointing out.
218 is pointing out.
Okay, fine. And then 217 is?
Admissibility of a confession.
Yeah, fine. What does it say?
I'll have to get.
You have the app there so that we all educate ourselves.
In fact, 219 is, I think, for the purposes.
219 is no problem with 219. Yeah, let's read it.
217 is quite lengthy.
Yeah, quite, yeah.
Yeah. Well, must I
Yeah,
place on
yeah.
record the whole of it? If it carries my land friend's blessing, Section 217 reads as follows. Admissibility of confession by accused. Subsection 217(1). Evidence of any confession made by any person in relation to the commission of any offense shall, if such confession is proved to have been made freely and voluntarily by such person in his sound and sober senses and without having been unduly influenced thereto, be admissible in evidence against such person at criminal proceedings relating to such offense, provided, paragraph A, that a confession made to a peace officer
Just bring that thing here. It's not what I want us to read. You know what I want you to read?
No, I don't. what you are thinking.
Yeah. Yeah.
Perhaps they could have in mind the confession made to a magistrate that is prima facie.
Yeah. All right, see. Yeah, just listen, here it is. It's admissibility of facts discovered by means of inadmissible confession. It's section 218, subsection 1.
Yes.
You know,
Yes.
evidence may be admitted at criminal proceedings of any fact otherwise in evidence, notwithstanding that the witness who gives evidence of such fact discovered such fact or obtained knowledge of such fact only in consequence of information given by an accused appearing at such proceedings in any confession or statement which by law is not admissible in evidence against such accused at such proceedings, and notwithstanding that the fact was discovered or came to the knowledge of such witness against the wish or will of such accused.
I'm still trying to understand the...
Okay, you remember Ginanda?
Yes.
Ginanda, you kept on asking him, how does he know that accused number 1 is involved? How does he know that accused number 2 is involved, etc., etc.?
Yes.
And Ginanda said, as the investigating officer, after accused number 1 allegedly made a confession to Maboto, I went to fetch the confession the following day, and I read it. Remember?
Yes, I remember that.
The same thing he says about accused number 2, I think. Rapadi, after Rapadi had made the confession,
Yes.
written the confession,
Yes.
this guy repeats to say he went to fetch it and read it.
And read it, yes.
The same thing with the magistrate Kronje. After he gave the confession to Mrs. Kruger, the senior,
He did the very same process.
he did the same thing. So in
Yes.
other words, if you read this, you'll get what is meant by this. So he acquires that knowledge, Kininda, by the fact that he read the confessions. And that evidence, according to this section, is admissible to him. But it is not as admissible as against a co-accused.
Yes.
Fine, you have heard me now. What do you think, Mr. Baloy? Is it witchcraft?
Yes, in fact, we quote in the case of Korashi, I think, that deals precisely with that.
Okay, fine. Let's go ahead.
B. Awareness of the attack, the accused must have been aware of the criminal attack was taking place. There is no evidence that accused 4 was aware that the criminal attack was taking place.
Okay.
C. Intention to make common cause. The accused must have intended to make common cause with the other participants or those committing the assault. There is no evidence that accused 4 intended to make common cause with those committing the assault. D. Active association with the attack. The accused must have manifested his sharing of a common purpose by himself performing some acts of association with the conduct of others. There is no evidence that accused 4 manifested his sharing of a common purpose by himself performing some acts of association with the conduct of others.
Okay.
E. Intention to kill the deceased or to contribute to his death. the accused must have had intention to kill the deceased or contribute to his death. There is no evidence that accused 4 had intention to kill the deceased or to contribute to his death.
Khanisa phakathi kwicala lezombuso ke futhi Malawa elingarapotiwe lapha ekhaya case number khona wathi AR2 elakade isinqumo sakhona sethulwa ke ilanga la nge-12 zaka October ngo-2018 inkosi inkantolo uphile ke lapho ke athi ngaphansi ko paragraph 19 ke lapho uma eqaphula khona ke lapho ke bathi inkantolo khona ke yasho kanjalo malana nokwenza into ukuthi lapho nihlele phansi ke niyiqembu ke lapho ke athi malana nodaba lozomthetho ke lapho uma sekusenziwa lokhu ke lapho ke athi kwamele ukuthi kubheke lokhu kulandelayo futhi ngendlela elandela ukuthi ngabe mhlambe abasola ke lapho ke baqhumana kanjani bonkana kuphecelezi nalo daba noma lecala lelo ke noma nofakazi ade bukhona ke lapho ukuthi mhlawumbe ke ngabe ade buhamba kanjani futhi busho kanjani ke kuthizeni ke lokhu abasola bakwenza nabonkana behlangene futhi behlele ihlelo elilodwa ukuthi benze lokhu ke lapho ke wabe futhi eqhubeka phecelezi nenike icala lapho ke lombuso futhi libhekene lapho kulomgedezi icala la ngo-1989 lapho ke volume 1 SA 687 ke lapho ke la bafunda khona ke phecelezi namaphuzu amahlanu ke lapho ke uma ngaba bekhuluma phecelezi ngodaba lokuhlela ke icala ningabantu abaningi ke lapho ke noma niqembu nehlele into ethizeni mhlawumbe nenze ke lapho kulaphula umthetho mhlawumbe ubugebengu ngokuthizeni ke lapho ke athi kwamele ukuthi iphuzu lokuqala ke lapho ke abakhuluma ngalo ke lapho ke kuqala kamgedezi ukuthi lapho ke abantu kumele ukuthi babe khona ke ngaphansi kwendaba yesigameko lapho ke noma babe khona ngaphakathi kwindawo yesigameko besebenze lokhu ke lobugebengu ke lapho ke kade bebenza noma mhlawumbe kade behlele ukuthi babenzeke lapho ke bese iphuzu lesibili ke lapho ke ukuthi wazi ukuthi ngebo empeleni niyahamba niyohlasela ke lapho ke bathi khona ke lapho kumsolo naye kwamele ukuthi abe nalo kulwazi lokuthi lapho bayahamba bokwenza kobugebengu lapho ke abathi futhi iphuzu lesithathu ukuthi abe nenhloso futhi enze lokho ngokuyimisela ekuthizeni naye adlala ke isikhangiso kulobugebengu ke lapho ke bathi futhi iphuzu lesihlanu ukuthi nake futhi abe khona ngaphakathi kulophuzu lesine ke lapho ke ukuthi naye abe khona ke futhi ngaphakathi ekwenzeni kobugebengu ke lapho ke futhi iphuzu lesihlanu ukuthi lapho ke naye futhi abe nenjongo yokuthi izini ke naye abe nesandla ekuthizeni babulale noma ke busola naye basho khona ukuthi umsola lapho ke lokho yena ke kumele abe nalo ulwazi lwakho ukuthi yebo lapho kade behamba bekwenza lokho ke athi malana nophecelezi udaba lolu becaphula phakathi icala lombuso libhekene necala likamgedezi ke lapho ke kade bekhuluma ngalo ngaphansi constitutional court lapho ke yana ke eNingizimu Afrika ke ngesikhathi becaphula lapho kummelweni ke futhi eqhubeka washo khona njalo phecelezi nodaba lwenkulumo ekade lethwe lapho ke uzungu ke ukuthi uzungu yena ke into ayikhuluma noma inkulumo eqhamuka kuyena ke ukuthi lapho komsola wesine ke lapho ke kade angamazi futhi uzungu yena akakazi ukuthi futhi uzungu wahlangana nabo ke lapho ke hostel egwabeni ke lapho ke futhi kwabagwabeni owazisa ke abantu abake kuyena ke uzungu ke ukuthi naba ke abantu abathizini ke lapho ke bathi uzungu ngemuva kwesikhathi ke lapho kwahlangana futhi umsola wesine futhi umsola wesibili uqala nowesibili nosithathu ke lapho ke ngesikhathi ebengena ngaphakathi lapho kumuzi kwagwabeni ke lapho ke bese ke nomsola wesihlanu wahamba wongena ngaphakathi kwala music ngesikhathi umsola wesihlanu ngena ngaphakathi ke lapho ke kade asalo emuva komsola wesine ke lapho ke bathi futhi uzungu khona ke la inkulumo yakhe bengahambisani khona ke futhi beyakhuluma futhi abuye ayilungise phecelezi nenkulumo yakhe ke lapho ke bathi kwesinye isikhathi uzungu washo khona njalo ke lapho ke ukuthi bekayimisela ukuhamba ngemoto yakhe kepha ke ngesikhathi bekazimisela ukuhamba ngemoto yakhe ke athi kula uqapha khona ukuthi ukhiya wemoto kade ungekho ke kena bese washayela ke bese ugwabeni ke washayela ka umuntu uthizeni ke ekhuluma naye phecelezi ucingweni phecelezi nodaba lwezikhiya lezi emoto ke lapho ke bathi uzungu nawacaba ukuthi mhlawumbe umsola wesine ke lo ugwabeni beyakhuluma naye ucingweni phecelezi nodaba lwekhiya lemoto ke kepha umuntu kade bembiza ngegama noma igama lakhe kade bemiza njengokuthi umuntu kade kumzala ke lapho ke bese nokucabanga ukuthi mhlawumbe kade kumsola ke wesihlanu ke loyo ke bekashayela ucingo kepha akaze liphendule ke ucingo lwakhe ke lo muntu loyo ke wabuya futhi uzungu wakhuluma phecelezi nodaba lwenkulumo yakhe ke lapho ke noma phecelezi nodaba lwekhiya lapho ke la wathula khona ufakazi bakhe ukuthi lapho ke ngesikhathi kade kusetseka lokho ke lapho kuzungu Uzungu wakhuluma ufakazi bakhe ukuthi lapho umsola wesine ke wafika ke lapho ke ngemuva ukuthi afike kwesi wamnika lapho ikhiya zakhe zemoto futhi ke ngesikhathi eqeda ukumphaka ukhiya bemoto ke lapho ke athi nabe kajabulile futhi bekasebenzisana nje kahle futhi wamshala ke izandla lapho ke washo khona njalo uzungu ngesikhathi ufakazi bakhe lapho ke ekhuluma pictures nodaba loluko elohlelo lakhe kuthi na ke lapho ke lokho ebonaka akakazwe abezwe ke bekhuluma pictures nokuhlelo nalo hlelo lwabo ke noma bezwe mhlambe noma ababone bevele bekhulumisana beqeda bobonkana abasola lapho ukuthi bezohamba webulala ke lapho ke umufi ke wabuya futhi ummeli washo khona njalo ukuthi malana nodaba lolu ke lapho ke pictures nodaba lecala leli kaMgedezi ke athi uma ngabe ke abantu behamba bebulala kumele ukuthi sibe khona ke sivumelwano lapho bazothi bavumela khona ke ngento eyodwana ke futhi kukhona ke amaphuzu amahlanu ke lapho ke aphule khona ke lapho ke ummeli iphuzu oqala ukuthi lapho ke kumele ukuthi umuntu ke abe khona ngaphakathi kwindawo yesigameko lapho ke bathi khona ke njalo ke kepha kumsola wesine nakade angekho ke lapho ke ngaphansi kwale ndawo yesigameko ngesikhathi ke kade kusenzeka lobugebengu ke lapho ke bathi futhi kumele ukuthi umuntu abe nolwazi lokuthi yebo siyahamba siyohlasela ke lapho nonke ehanjwe kuyohlaselwa ke lapho ke bathi khona ke njalo umsola ngamunye ke lapho ke kwamele ukuthi azi ukuthi udlala isikhangiso siphi uma ngabe senza kusenziwa ke lolu hlelo ke lapho ke bathi ke phaka bukho ufakazi obusho khona njalo ukuthi umsola wesine ke lapho ke yena kade analo ke ulwazi lokuthi bahamba bokwenza lokho ke kule ndawo kade isenzeka kuyona ke lobugebengu ke lapho ke bathi futhi umuntu yena enze futhi ngenjongo mhlawumbe yebo enze ngento ejwayele ngendlela futhi ekhethekile ekuthizena ke kade isikhangiso ke lapho ke bathi khona njalo kwabukho ufakazi obusho khona njalo lapho umsola wesine ke nakhe kade khona ke lapho ke futhi naye wahambisana nabanye ke bonkana benza njengethimba noma njengeqembu ke lapho ngesikhathi kade bokwenza ke ubugebengu lobo ke bathi futhi kwamathi lapho wasebenzisana nabo ke abanye futhi oza kwabo ke uma ngabe sebenza lobugebengu lobo ke bathi futhi lapho kuyasho khona njalo umsola wesine ke lapho ke akukho la kusho khona ukuthi nake kade khona ke lapho ke futhi noma kade analo ke ulwazi bezothi futhi bele ukuthi abulale ngenhloso ke lapho ke bathi khona ke njalo futhi uma ngabe sebenza lokho ke umuntu abulale ngenhloso ke njengabanye ke lapho ke abasolwa ke ekuthizini bafezekise lokuzana ithimba labo ke noma mhlambe ukuhlela kwabo ke kuzinto njengethimba ke lapho ke bathi khona njalo umsolo wesibili ke lapho ke nake akanalo ulwazi futhi akazenzela lokho ke ngenhloso ekuthizini ke abe nesandla ekuthizini ke umufi ashona.
The effect of failure to call available witnesses. The failure of a party to call a witness could, under certain circumstances, justify an adverse inference against that party. It is generally true that where a party fails to lead evidence, available evidence, which can clarify the facts before court, such failure leads to the inference that it is feared that such evidence will expose the facts unfavorable to that party. In this regard, my Lord, Ms. Kelly Kumalo was not called to testify despite being the complainant on the third count of the indictment. An adverse inference will be drawn in circumstances where the state failed to call another witness or witnesses as corroboration, where such witness or witnesses were available to give evidence and was in a position to clarify facts relevant to the case. Evidence of identity. Evidence tendering to prove the person's identity may be direct or circumstantial evidence. Direct evidence is the testimony of the witnesses who says, for example, that the accused is the person whom he saw emerging from the shop at midnight. I submit that there is no witness or witnesses that place accused number 4 at or near the scene of crime. The witnesses who testified viva voce before this court did not implicate accused number 4 as one of the intruders, or that at some point they, that is the intruders, after they had fled, another intruder entered the house. The assertion by Brigadier Kininda that accused number 4 entered the house must be rejected as false beyond reasonable doubt, as they do not find support from the witnesses. Mthokosiziseni Maphisa, who ran out of the house after shots were fired, did not mention this, nor it was raised by the state in examination in chief or when the state was leading this witness. No, the witnesses, Ms. Makete and Mr. Ngache, observe another intruder after the two intruders had fled the scene, coming out of the premises. Despite Brigadier Ginda, my lord, reading the confessions, it is clear that he did not do any investigations in order to corroborate and find evidence alluende to the commission of the offense. I'm basing this because if it is true that accused number 4 entered the house after the two intruders had left, this was supposed to be investigated, and no investigation emanated from this point. The DNA evidence and fingerprints. Captain Mamshedi Phineas Masetla testified that he was the senior forensic analyst and in the service of the state. He undergone training when he joined the Forensic Science Laboratory in 2002 with reference to opening of parcels containing biological evidential material, the preliminary testing of body fluids thereof, and DNA techniques which he had offered knowledge and skills for forensic biological analysis. He testified that he received continuous training with the Forensic Science Laboratory up until 2006. He had approximately 25 years experience in the biological sciences. He was responsible for analyzing the DNA results in terms of doing the interpretation of the DNA results. He will then do what they call DNA comparison, where he will then have a case like this one, where he will have the DNA from the exhibit, from the scene, and they will also have the DNA results from the reference sample. The reference sample are the samples that are taken from the suspect or accused individuals. Captain Masetla further testified that he compiled what he got from those particular exhibits when conducting his investigations. The lab number allocated for the exhibits from the scene is lab number 217731 of 2014, and lab number for reference sample is lab 126265 of 2016, phosphorus case 636 of 2014. The exhibit and reference samples were contained in exhibit X11 of the record. On the 9th of October 2023, the records depict the following at page 75, line 2 to 4. Captain Masetla. At number 22, which details the description of suspect Mthokosiziseni Maphisa accused for, was excluded from all the samples. Close quotation. A report compiled by Captain Masetla, exhibit X12 in bracket, contains a table where the relevant results from the exhibit from the scene and reference samples are compared. The first sample is written sample with an indication of 1, that is swab 1, which has the container number 14DCAH8988 and contained in bag number PA 400 2150107, which was taken from the door handle of bedroom 1. The next exhibit is a head, which is exhibit B on the head DNA, and is analyzed with presumable high friction area. In simple terms, it is a sweat. A head was in evidence sealed bag number PA 3000 788535. Captain Masetla received the first reference sample for MZ Maphisa in container number 19DBA F0198 in seal bag number PA 400 4638062. The second sample that he received was from Mthokosiziseni Maphisa in container number 13DBAD 5906 in seal bag number PA 500 2176171. On the 9th of October 2023 at page 77, line 1 to 6, Captain Masatla said the following. When you go to the next column, it is written gender marker or Emala Godin, which tells us the donor of that particular sample, if the donor is a male. If is a male, it will be XY, and if it is a female, it will be XX. In the context of a gender marker, if you have XY, it means that particular mixture, it can be a mixture between a male and a male individual, or simply terms, it can be a mixture of both or more than one male individual. So, and as well as if you still have that XY, it can be a mixture of a male and a female individual. So when you look at XY on a mixture DNA, you must always remember that XY, it does not mean that that mixture is an only male individual mixture. So in a mixture, that XY represents XS, which is a female, or XY, that is from a male individual. He testified that on the 10th of October 2023, page 2, line 13 to 24, my lord, it is important that before I start checking whether I find that DNA in the swab or in the head, is that for us to say a person is included, you must have to include the person in all DNA regions. So reading a person in one single region does not mean that that person is included in the mixture. Mr. Prosecutor. Now, what is the position if you read that person more than one region, Captain Masadla? If you read him in more than one region, you must not, for you to conclude that that person is a contributor of that mixture, we have to read him in all the DNA regions. There was a question by Mr. Malloy to the following. Are there any of these regions or loci that are more important than the others? In other words, that are more distinguishing? Captain Masatla asked that the following. We, in terms of distinguishing the character of the loci, we use them in combination to give us a distinguishing factor. So we combine them. It is not necessary to say we attach more importance to one than the other. We match importance to the combination of them all together. From what follows from the evidence of Captain Masatla, my lord, was the analysis and comparison of swab 1, assembly head B, and various reference samples of known individuals, including Mthokosiziseni Maphisa, accused number 4, and he came to the following conclusion. The donor of the following reference sample were excluded as the donor of the DNA on the swab 1, 14DCA H8988, and the head B presumable high friction area PA 3000 788-535, Phosphorus, case 636 of 10/2014. The importance of this report or results, my lord, is that circumstantially it further excluded my client, accused number 4, in the commission of the offense. The sole purpose for the head to be sent to this forensic science laboratory was in relation to the friction area, whether one look at whether the head has a sweat not as what Brigadier Kininda wanted this court to believe. He did his own analysis, which do not find support from the report by Captain Masetla before court. Brigadier Kininda merely says that because the accused, that is accused number 4, is read in one of the regions, then one can conclude that such a report is positive. That does not find support, my lord, from the evidence of Captain Masetla. And Brigadier Kininda further testified that because the accused is read in one of the regions, it is possible that he had touched the head. That was not the sole purpose for this head, the exhibit, to be forwarded to the Forensic Science Laboratory for examination. The evidence of Sergeant Vusumuzi Mohane. Sergeant Vusumuzi Mohane testified that he is employed by the South African Police Service attached to the National Court Cases Unit. He testified that on the 20th of June 2020 at about 2100 hours in the evening, he was in the company of his colleague, the late Sergeant Mabena, when he arrested Bongani Ntanzi, accused number 2, at Phokeng in Rustenburg. On the 19th of June, accused 2 appeared before Lieutenant Colonel Rapado for a confession at Moroga Police Station. Accused 2's confession statement was admitted as Exhibit HH of the record. On the 24th of June 2020, the accused appeared before a magistrate, Ms. Cronje, for a second confession statement, Exhibit JJ of the record. On the 6th of October 2020, acting on the information that accused 2 had provided in his confession statement, Brigadier Kininda arrested accused number 4. Brigadier Kininda considered in his evidence in chief that he arrested the accused, that is accused number 4, based on information provided to him, that is Brigadier Kininda, by accused number 2 in his confession statement, that he, Brigadier Kininda, had no evidence against the accused, that is accused 4, before the confessions were obtained. Confessions not admissible against another in terms of Section 219 of the Criminal Procedure Act 51 of 1977. Section 219 of the Act provides that no confession made by any person shall be admissible as evidence against another person. In the Constitutional Court decision of Mhlongo and Nkosi versus the state, which was penned by Judge Theron, or Justice Theron, the crucial issue, my lord, was the admissibility of extrajudicial statements of accused against a co-accused in a criminal trial. The issues arose in 2 applications in which the applicants seek leave to appeal against their conviction and sentences. The court, that is the Constitutional Court, was called upon to determine the constitutionality or constitutional validity of the admissibility of these statements. At paragraph 18 of the judgment, the Constitutional Court justices find history of the common law prohibition on extracurricular statements against co-accused. At paragraph 18, I quote the following. At common law, the extracurricular statement of an accused was inadmissible against a co-accused. This common law prohibition stemmed from English common law. In 1832, the Court for Crown Cases Reserved in R. versus Turner was called upon to pronounce on a conviction for theft. The conviction was based on the evidence tendered in a confession of a co-accused who was an employee of the complainant. The court unanimously held that the confession of an accused was inadmissible against a co-accused and the conviction was thus wrongfully made. Close quotation. A confession of one accused may not even be used indirectly against the co-accused. What is meant appears from the judgment of State versus Batman, 1960, Volume 3, SA 535, capital letter A in bracket. In which case the three accused were convicted of murder. One of them made a confession implicating the other two. All that connected the confessor to the murder was his confession, and all that lined the other two was that the three were in each other's company on or at about the crime of the offense. Although the direct implication of the other two in the confession was therefore correctly left out of the court's considerations, neither JA found on appeal that they were nevertheless indirectly and wrongfully connected to the murder thereby. The decision based on Wigmore paragraph 1076, an English decision in R versus 10, 168 ER 1298, and the appellate division decision in R versus Nkosi and Zulu, 1950, volume 1, parenthesis all, H 91, capital letter A in bracket. Batman's case was followed by the appellate division in State versus Sorobe, 1968, volume 4, SA 420A at 425G. A confession may not feature at any point in the chain of inference. Even indirect use of the confession for purposes of corroboration is not permitted. In this regard, see State versus Makeba and another 2003, volume 2, SACR 128, SCA at 133, paragraph 14. It follows, therefore, that no reliance should be on accused number 2's confession as corroboration of Zungu's evidence, either directly or indirectly. My emphasis. Section 39, subsection 1B of the Constitution, which requires a court when interpreting our Bill of Rights provisions to consider international law. The term used is must. In terms of section 39(1)(c), also indicate that reference may be had to foreign law, but not prescriptive. It provides that only the court may consider it when interpreting those provisions. South African courts actively consider international law when interpreting the rights to a fair trial in terms of section 35 of the Constitution, ensuring that the domestic legal procedures align with international rights standards. The English common law in relation to the admissibility of extraocular statements is useful summarized in the following passage of Lord Elsham of St. Mary's-Bourne, Hillsberg, Law of Evidence, 4th edition, 1990, volume 11, 2 in brackets at paragraph 1131. And I quote, confessions by one or two or more accused, where several persons are accused of an offense, and one of them makes a confession or an admission, that confession or admission is evidence only against the party making it. Where the statement is admissible, the information in it may be used to extract from the accused in the form of evidence made on oath all that he has formally said about a co-accused. Statements like acts done by one of several accomplices or conspirators in pursuance of a common design are evidence against the others, but statements which not made in pursuance of a common design are evidence against the makers. close quotation. The bank records. In terms of section Section 236 of the Act, the state produced proof of entries in accounting records and documentation of bank records, Exhibit EE, subsection 3 in brackets of accused 4. The relevant pages of bank records are pages 21 to 25 and cover the period from the 28th of August 2014 to 30 April 2014. The state indicated that the relevant pages of the bank records were page 24, the entries of 25 October 2014 to 27 October 2014, which depicts the following on page 24. There is nothing in the bank records, my lord, that suggests that accused 4 received any proceeds from the mastermind for the killing of the deceased. In fact, the record supports the accused version, and there is nothing that turned out of them in the state presentation of the bank records that implicates accused number 4. As they show the inflow and outflow of funds, which are immaterial in the present case. My lord, I'm informed that it is $1,300.
Is that so?
Yes. May the court adjourn for lunch.
Until 2 o'clock, is it?
that the number 27713953801 was his cell phone number. The Section 205 records analyzed by Lieutenant Colonel House disclosed communication amongst the accused in 2020. Exhibit DD5 in bracket, capital letter B in bracket. Do not disclose any communication between accused number 2 and accused number 4, Mr. Maphisa. There are no Section 205 records for the period of 2014, which were going to be central in this case in relation to the incident of the 26th of October 2014. Colonel Stein testified that this was attributed to the fact that a period of 3 years had lapsed when he did the analysis. The doctrine of joint possession of firearm. Joint possession of a firearm, particularly an illegal one, requires proof that more than one person intended to possess the firearm and that they did so together, not just that one person possessed it on behalf of a group. The mere presence of a group during the robbery where a firearm is used does not automatically equate to joint possession. Evidence must show a common purpose to possess the firearm, with either the actual possessor holding it on behalf of the group or the group intending for one of them to possess it on their behalf. In State v. Nkosi, 1988, Volume 1, SACR 284W at 286, paragraph H to I, it was that held as follows, that this is justifiable in a factual evidence if the factual evidence exclude all reasonable inference other than A, that the group had the intention to exercise possession through the actual detentor, and B, the actual detentor had intention to hold the gun on behalf of the group. Only if both requirements are fulfilled can there be joint possession involving the group as a whole. In Makubela versus the State, Majeke versus the State, CCT 216 of 2016, also reported in 2017 ZACC 36, 2017 Volume 2 SACR 665 CC, 2017 Volume 12 BCLR 1510 CC, dated the 29th of September 2017 at paragraph 45. Quoting from the State versus Nkosi, 1988 Volume 1 SACR 284, capital W in bracket, at 286H2I, the court said the following, and I quote, "The issue which arise in deciding the group, and hence the appellant possess the guns, must be decided with reference to the answer to the question whether the state has established facts from which it can be properly be inferred by a court that A, the group had intention animus possidendi to exercise possession of the guns through the actual detentor, and B, the actual detentor had the intention to hold the gun on behalf of the group. Only if both requirements are fulfilled can there be joint possession involving the group as a whole and the detentors or common purpose between the members of the group to possess all guns." Close quotation. The Constitutional Court acknowledged that there will be very few factual scenarios which meet the requirements to establish joint possession. This is because of the inherent difficulty in proving that the possessor had the intention of possessing a firearm on behalf of the group. Awareness alone is not sufficient to establish intention of joint possession or possessing a firearm, or the intention of holding a firearm, or the intention of holding a firearm on behalf of the group. Whilst common purpose can be used to prove possession by the group, it is not sufficient on its own to establish joint possession. The state needs to prove beyond reasonable doubt that the accused had intention to possess the firearm either personally or through another member of the group, and that they had the ability to exercise control over it. The evidence of Sergeant Manda Richard Masondo. Sergeant Manda Richard Masondo testified that he is a member in the South African Police Service attached to the Provincial Taxi Violence Unit, which is the sub-unit of the Provincial Organized Crime Unit. He testified further that on the 9th of February 2015, he was on duty during police investigations in the company of his colleague, Sergeant Lamin. While on duty, he received an information about the suspect he was looking for. As a result of their investigation, a 9mm Czech Republic loaded with 15 rounds, live rounds of ammunition were found, and one ammunition was on the chamber, and a blue box with 12 live rounds of ammunition with different caliber in a room allegedly occupied by accused number 3. They proceeded to Cleveland Police Station to open a case of possession of unlicensed firearm under Cleveland Case 96 of 2, 2015, SAP 1386 of 2015. A firearm was sealed in evidence bag number FSE 385083. The evidence of Lieutenant Colonel Christian Mangena. Lieutenant Colonel Christian Mangena testified that he is stationed at the Ballistics section of the Forensic Science Laboratory and employed as a forensic analyst. On Monday, July 2020, during the performance of his official duties, he booked out and exhibit firearm and ammunition at Cleveland Police Station under Cleveland Case 96 of 2, 2015, SAP 1386 of 2015. The exhibits were received in an open evidence bag number PA 4000810885 and were booked out for further investigation purposes as per Phosphorus Case 636 of 10, 2014. On the 27th of July 2020, exhibits, firearm and ammunition were booked back at Cleveland Police Station, sealed in evidence bag number PA 400-440-4332. On the same day, the exhibits were booked out at Cleveland SAP 13 store by Brigadier Geninda. Lieutenant Colonel Mangena testified that he compiled a report in terms of Section 212, subsection 4, small letter A in bracket, and 8A, small letter A in bracket, of the Criminal Procedure Act 51 of 1977 as amended, Exhibit X 13 in bracket C in bracket. He recorded his findings at paragraph 9.1 of his report. The cross-examination of Tumelo Madlala. Mr. Ramsepele asked the following question, and I quote, and then also could you tell if the firearm had a wheel on the side, something that looked like a wheel or a rotating object on the side? Madlala, I looked it, like I have already said, that I did not take a lot of time to observe that particular firearm, but it looked to me as though it was a firearm that had a wheel on it. You find this on the transcribed record dated the 8th of August 2023, page 6, lines 16 to 22. Advocate Mnisi posed the following questions to Mr. Madlala. Thank you. But now this one, a distinctive feature of it, it looked like there is a wheel. Mr. Madlala responded in the following respect. Yes, I have already said that, yes. And when I looked at it, I saw it from the front portion of it. Close quotation. They were said, Watermeyer J.A. in R. versus Blom, 1939 AD 188 at 202 to 203, two cardinal rules of logic that could not be ignored when it comes to reasoning by inference. 1. The inference sought to be drawn must be consistent with all the proof facts. If it is not, then the inference cannot be drawn. The proof facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. If they do not exclude other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is the correct one. Thus, From the evidence of Tumelo Madlala during cross-examination, the proof facts of the ballistic report cannot be the only reasonable inference to be drawn, as they do not exclude every reasonable inference to be drawn. Then there is doubt whether the inference sought to be drawn is the correct one. The test for joint possession of an illegal firearm is well established. There is no independent evidence that accused for participated in the murder and the subsequent robbery, or that he was part of the conspiracy to kill the deceased. The state did not prove beyond reasonable doubt the inference that he had intention to exercise possession through the actual danger, and that the actual danger had intention to hold the firearm on behalf of the group, except what is contained in the confession statement of accused number 2. In terms of the 5 principles I've alluded to, enunciated in the State versus Mkhete's decision, that is the presence at the scene, awareness of the attack, intention to make common cause, active association with the attack, intention to kill the deceased or to contribute to his death, I find none. It follows, therefore, that the state has failed to establish a prima facie case in respect of counts 4 and 5 of the indictments, and to this end, he must be acquitted. Conclusion. It ought to follow that if a prosecution is not to be commenced without that minimum of evidence, so too should it cease when the evidence finally falls below that threshold. In short, my Lord, what I'm submitting in my heads of arguments is the following: that there is no evidence tendered by the state upon which this honorable court may convict accused number 4. The onus is not on the accused person to prove his innocence. It has always been the duty of the state to prove the case beyond reasonable doubt as far as 1961. It is not the duty of accused number 4 to go to the witness box and supplement the state case in any way, or incriminate, or by so doing, incriminate himself. For the aforegoing, I submit that the accused that is accused number 4 be acquitted and discharged in terms of the provisions of Section 174 of Act 51 of 1977, dated at Pretoria on the 15th of August 2015. Thank you. 2025. Thank you, my God. Thank you.
Okay, thanks.
lapho ke bekafunda khona ke umeli phecelezi malana nodaba lwesicelo sakhe ke lapho ke asho khona njalo malana nodaba lwesicelo sakhe ke lapho ke uma ngabe khuluma malana nodaba lofakazi noma ufakazi athe khona ke lapho ke uyasho khona ukuthi ithimba labashushisi lapho lehlulekile kakhulu ekuthizeni lapho lethi ufakazi noma ufakazi abakhona ke lapho ke noma ufakazi akade ukhona umangele noma ufakazi akade ukhona ngaphakathi kwalelikhaya ngezilanga lesigameko lapho ke wathi na ke ukhela ukhumalo wathi abakaze bambize ekuthizeni eze ngaphambi kubusenkantolo alethe ufakazi bakhe ke noma umuntu wesibili kade akhona noma wesithathu kade akhona ke lapho ke ngesikhathi kade kusenzeka ke udlamelo lokho nohlamba ubugebengu lokho kade kusenzeka ngaphandle kwakhala lakwakhumalo lapho ke waqhubeka futhi wakhuluma malana nodaba lofakazi futhi washo khona njalo lapho ke ukuthi ufakazi lobo kade bukhona ke lapho ke akukho ufakazi obukhethekile noma mhlawumbe ufakazi obuquka noma ufakazi obudirect lapho ke obuxhumana khona ke nomsola wesine mhlawumbe obukhomba khona ke kumsola wesine ke lapho ke futhi wenza ke khona ke ilokuzana sibonelo lapho ke labe yakhuluma khona ke ngokuthi ufakazi obukhethekile mhlawumbe ufakazi obudirect ukuthi mhlawumbe umuntu othizeni ke uma ngabe qhamuka ke esitolo lapho ke asho ukuthi yena kukhona ke umuntu othizeni awambona ke ngesikhathi sasebusuku ke futhi uma ngabe iqhubeka futhi esho khona njalo nodaba lakhe lesicelo lapho ke wabuya khona futhi ngodaba lwama DNA lapho ke akade khona ke lapho Captain Mampas Shady Phineas Masetla khona kufakazi ade wabulethile na ngaphambi kusenkantolo njengofakazi ke lapho ke la washo khona ke njalo ngesikhathi kade esethula kufakazi bakhe ukuthi yena kusebenza ngaphansi usho ukuthi yena ke i-senior forensic analyst ke lapho ke uchwepheshe ngaphansi kodaba lwama DNA lapho ke ngesikhathi athena futhi waqala ukusebenza lapho ke ngomnyaka ka2002 kepha kwahamba wafunda khona njalo ufundela lo daba lwama DNA lapho ke futhi athi unomnyaka u25 esebenza ngaphansi kwalomkhakha lona ke wama DNA analysis ke lapho ke futhi wakhulumile ukuthi ngesikhathi kade senza ke locwaningo lakho lomsebenzi yenake washo ukuthi nobaqade bemcela ukuthi enza kama DNA bamalana noma asho noma atolike ke lapho kama DNA kade akhona ke lapho ke noma aqhathanise phakathi kwama DNA ama samples kade akhona ke lapho ke futhi umuntu shuthi umkamsolwa futhi nesiqoqo lesi ke kade sitholakele lapho ke ekhali la kwakhumalo ke ngelanga lesigameko ke lapho ke futhi wabuya wakhuluma khona njalo ukuthi ngesikhathi lesi uCaptain Masihla bekenza ufakazi noma beyenza ukukwana umsebenzi wakhe ke lapho ke athi khona ke ilokozana ayithola ke izimbili ke lapho ke ilokozana ilab number ke yakhona kade ikhona ngaphakathi kwesikhwama lesi sofa semibukiso ke lapho ke bathi ilab number yakhona ke lapho kade ku 217731/2014 bese khona enye futhi khona ke lab samples kade khona ke lapho ke kade ku lab 126265/2016 yase phosphorus ihamba le case akhona 636/10/2014 wathi ngesikhathi nade senza lokho kulukuzana ubaba uMasihla noma uCaptain Masihla ke lapho ke athi wakhuluma lokungaphansi komuqa wesi22 ke lapho ke ngokujulile ekhuluma khona njalo manana nelukuzana kaMsolwa kade wathi Mthokosiziseni Maphisa kade kumsola wesine ke lapho ke ukuthi yena ke yena ke umsola kade angekho kuhonkana lama samples kade akhona ke lapho ke futhi wabuya ukhuluma khona njalo manana ukuthi udaba lo kade beshicilele ngaphansi ke ngelanga la nge9 ngenyanga yes10 ke lapho ke ngomnyaka 2023 ngaphansi kwikhasi 75 kumuqa wesibili kuze kufince kumuqa wesine ke lapho ke washo khona njalo ukuthi lapho ke umnumzana olokuzana uMasihla ke washo khona njalo ke ukuthi lokhu wakufaka ngaphansi kumibukiso kaX12 ke lapho ke kade akutholile ngesikhathi lesi kade asenza kumsebenzi wakhe ke lapho ke futhi washo ukuthi khona kama swap yena ke wathola lapho ke swap eyodwana ke kade khona ngaphansi container ke ekade ku 14 DCA H 8988 futhi nye container ebag isikhwama esingathi sikhona ke lapho ke uzofaka ngaphakathi ko PA 4002150107 bese wathatha lokho kokuhambisa ke ngaphansi kwegumbi la bagcina khona ke izinto ke washo khona njalo ukuthi khona ke obunye futhi eminye futhi imibukiso ke engaphansi kwemibukiso ka B exhibit B ke lapho ke yama DNA la ngesikhathi kade senza kucoco umsebenzi wakhe uqhathanisa phakathi kwalama frictions ama area atakhona ke lapho ke nokuthi mhlawumbe ngabe kade khona ukujuluka yini kodwa akutholile ngaphakathi kwela sample ke lapho ke washo ukuthi wakubhala lokho ngaphansi kwe exhibit bag wasayisila ke noma wasivala ke isikhoma sakhona ke ngaphansi ko PA 3007007888535 bese waqhubeka khona njalo ke washo lapho ku Captain Masihla ukuthi ke into eqala isample awayithola ke lapho nama sample ade nayo lapho ke kade ku MZ Maphisa ke kade ngaphansi kwe container lapho ke kade inale inombolo ezilandelayo ke lapho ke kade emakhiwe lapho ke noma iqapho 19 DBA F0189 bese kwafaka ngaphansi kwesikhwama ke lapho ke futhi isikhwama sakhona so kade sinale inombolo ezilandelayo ke lapho ke kade ku PA 4004 6380 62 bese ke enye futhi lokozana isikhwama sesibili ke noma isample esibili kade nayo ke na ke kade atholile ke kade ke Mthokosiziseni Maphisa ke lapho isikhwama leso sofaka ngaphansi kwale nombolo ezilandelayo 13 DBA D5906 bese wabuya kwafaka ngaphansi kwesikhwama esisodwa ke lapho ke kade bese ngemuva ukuthi afake ngesikhwama ke leso ke futhi isikhwama kade sinale nombolo ezilandelayo ke lezo ke zaka PA 500 2176 bese waqhubeka khona njalo uMasihla washo khona njalo ukuthi khona ke ilokozana ke lapho ke ama DNA analysis abavame ukuthi mhlawumbe abasebenze ngayo ke evame ukuthi keep lapho ke ulokozana ubulili bomuntu ke lapho ke sokuthi bathi XY ke lapho ke sokuthi umuntu osilisa ke bese lapho ke bathi elandelayo ke sokuthi u-XX shuthi yabantu besimame-ke lapho-ke washo khona njalo ukuza noma sehla kuthi khona-ke njalo khona-ke lokhu malana nodaba lolu alibhalile noma olukhuluma-ke lapho-ke kukuthi u-X washo ukuthi-ke lapho-ke yinto-ke mhlawumbe yomuntu oyedwa noma mhlawumbe sehlangene nomunye-ke wesibili-ke lapho-ke wesilisa-ke noma-ke shuthi isampula khona-ke ingahambile kanjalo mhlawumbe sehlangene-ke nenye-ke futhi umuntu wesilisa noma mhlawumbe umuntu oyedwa wesilisa-ke kuphela-ke kuvame ukuthi lapho kube u-XY-ke athi kepha-ke khona-ke esikhathini esiningi ukuthi mhlawumbe kuyenza ukuthi zihlangane lezi lamasampula amabili-ke so mhlawumbe kube khona yesimame eyomuntu wesimame futhi nomuntu wesilisa-ke lapho-ke wathi kuvame ukuthi lapho kube u-X athi XY-ke lapho-ke futhi wabuye waqhubeka wajobelela washo khona-ke njalo umelwenu ngesikhathi bekakhuluma khona lapho-ke ekhuluma lapho-ke athi lokhu khona kubhaliwe ngaphansi kuka-column lapho-ke lokhu ngaphansi ku-STR lokhi sho ukuthi le-STR lokhi yakhona-ke beyakhuluma njalo ukuthi lama-regions lama-blocks abhala khona kama-DNA forensic analysis akhona-ke lapho-ke la bathi khona-ke uma ngabe kade kusenzeka lokhu-ke lama-regions kwamele ukuthi ameshane ahambisane-ke lapho-ke bathi le nkulumo yakhulunywa ngaphansi kwenkulumo kade shicilelwa la ngaphambi kokusenkantolo ngelanga lange-9 ngenyanga ka-October ngomnyaka 2023 ngaphansi kwekhasi le-78 lapho-ke kumugqa wesi-23 kuze kufince kumugqa wesi-25 wabuya futhi wakhuluma khona njalo ngesikhathi bakhuluma ngodaba lwenkulumo kade ikhulunywe lapho-ke umnumzana noma sehla lapho-ke kade ibuzwa-ke inkosi yenkantolo ukuthi manje ngabe kubaluleke kangangani ukuthi lokho-ke umuntu uma sekahlola-ke lapho-ke noma ebukisisa kahle lo daba lama-DNA swap kwakhona-ke ukuthi wesigqoko-ke noma mhlawumbe isigqoko-ke lapho-ke ukuthi ngabe mhlawumbe ngasho njani ukuthi umuntu oyedwa-ke noma mhlawumbe somuntu-ke lapho-ke washo khona njalo ukuthi nalokho ngekho akusho ngokugcwele-ke ngoba-ke khona-ke udaba lwenkulumo mhlawumbe engasho ukuthi khona njalo kulama-regions kumele ukuthi ahambisane wonkana bese-ke afaneke lapho-ke bese wabuza-ke lapho umshushisi walana-ke enkantolo-ke lapho-ke ukuthi manje-ke ngoba mhlawumbe le simo kade ufunda ngakusona-ke shuthi ngabe mhlawumbe le DNA lona-ke shuthi iphuzu elilodwa ngekhe lona lisebenze yini-ke lapho-ke wathi yena nanoma usho njalo kepha ngeke umfake kwiphuzu elilodwana kuphela-ke ngoba kwamele ukuthi umfake kuwo wonkana lamaphuzu akhona-ke lapho-ke ngoba kumele ukuthi ahambisane wonkana uma ngabe sebahlanganise baxhumanisa lapho-ke ngokwendlela yabo yokusebenza-ke ama-DNA-ke lapho-ke futhi lokho kade kukhulunyiwe kade bekushicilele ngelanga lange-10 zaka-October ngomnyaka 2023 lapho kwikhasi lesibili-ke kumugqa wesi-13 kuze kufince kumugqa wesi-24-ke lapho-ke wabuya futhi umshushisi wabuza khona njalo ukuthi manje ngabe le nkulumo isho khona njalo kwama-regions lawana-ke noma le lokhu ukhulumile-ke ngayona ngabe mhlawumbe isho ukuthi nakumanye ama-regions vame ukuthi kuba khona noma mhlawumbe ngabe yini ekhethekile mhlawumbe-ke ekhona-ke lapho-ke bese wabuya waphendula ubaba umasehla-ke lapho kule nkulumo kade kulo mbuzo kade ubuzwa kumshushisi-ke lapho-ke wathi noma-ke khona kukhethekile malana nodaba lama-characters-ke lapho mhlawumbe ikhangiso zalamalokhi wakhona-ke athi esikhathi esiningi bavame ukuthi mhlawumbe basebenzise-ke lokhu kulandelayo ukuthi mhlawumbe-ke izinto ezikhethekile-ke lapho-ke uma sebebuka ngodaba lwama-DNA-ke lapho-ke washo khona njalo-ke lapho-ke wathi nanoma-ke esho khona-ke njalo kubaba umasehla-ke loyo-ke lama-analysis comparison wakhona uswap lokuqala-ke lapho-ke lingaphansi kwesigqoko-ke usho ukuthi we-head B-ke lapho-ke athi futhi nokunye-ke lapho kwama-samples-ke khona-ke kasho khona njalo ukuthi lapho-ke kujangala-ke umuntu oyedwa-ke lapho athi umsola-ke wesine-ke lapho-ke futhi wabuya washo khona njalo ekuqedeleni kwakhe-ke lapho umasehla-ke uCaptain Masehla-ke indaba yakhe-ke yama-DNA samples noma iy'phumo zakhona-ke ade aphume nazo-ke lapho-ke kuwukuthi lo muntu wesigqoko-ke noma umuntu abathola kuzona-ke le masampula yana-ke noma idona-ke noma mhlawumbe umuntu onikezeke idona-ke musho ukuthi umuntu abathole kuyena-ke lapho-ke lama-DNA swap ka-1-ke lapho-ke shuthi yena le nombolo ey'landelayo zika-14 DCA H8988 futhi esigqoko-ke lapho-ke ekade sikhona-ke ngaphansi kwale nombolo ey'landelayo-ke lapho-ke bathi u-PA 3000788 bese bathi yase-Phosphorus wathi case 636 of /10 2014 wabuya futhi eqhubeka washo khona njalo kwathi u-MZ Maphisa-ke unale nombolo elandelayo uma sekafakile uma efake-ke inombolo zakhona-ke ngaphakathi-ke bathi 19 DBA F0189 bese wathi open bracket wathi close bracket baphinda futhi wafaka amanye ama-bracket lapho-ke bathi u-PA 400 4046 38062 bathi lapho kuMaphisa Mthokosiziseni Maphisa futhi ngaphansi kwakhe khona ke futhi ezinye inombolo ezilandelayo ke lapho ke u13 DBAD 5906 bese bafaka ama bracket bese baphinda futhi ke bafaka ezinye inombolo ezilandelayo wathi uPA 500 217671 babuya futhi washo khona njalo bathi khona njalo mara nodaba lofakazi kade kukhulunywa lapho ke umnomzana uSergeant Vusimuzi Mongane bathi nake uVusimuzi Mongane washo khona njalo ke ngesikhathi bekaletha ufakazi bakhe washo ukuthi usebenza ngaphansi kwezesiphoyisa yakhe usebenza njengephoyisa yakhe lapho ke futhi naye usebenza ngaphansi kweNational Cold Cases Unit. Ngesikhathi leso athena ke waletha ufakazi bakhe washo ukuthi ngelanga lange-20 zakaJuni ngomnyaka 2020 ngehora laka-9 ebusuku khona njalo ke lapho ke kade hamba nomunye uzakwabo besenza kumsebenzi wabo zesiphoyisa ke lapho ke athi kulaba bopha khona ke uBongani Ntanzi ke okumswalo wesibili kade eboshwa lapho ke ePhukeng eRustenburg ke noma ngaphansi kwendaba kwedolobha laseRustenburg ke bathi ngelanga lange-19 zakaJuni ngomnyaka 2020 ke umswalo wesibili bese yena ke lapho ke waqhamuka ngaphambi ko-Lieutenant Colonel Rapadu ngesikhathi lesi bade wahamba ukwenza khona ke i-confession ke lapho ke eMorocco ngaphansi kwesikhumulo samaphoyisa saseMorocco Police Station lapho wathi umsolo wesibili wenza udaba lwe-statement lo-confession ke lapho ke bese babela kwafaka ngaphansi kwemibukiso ka-exhibit HH ke lapho ke kade shicelela ngaphambi kokusinkantolo ke bathi ngelanga lange-24 zakaJuni ngomnyaka 2020 yena ke wahamba khona njalo ke wahamba phambi komantshi ke lapho uKronje ngesikhathi bekahamba kwesibili ngesikhathi ukwenza i-confession lesibili ke lapho ke ekhona ke ngaphansi ko-exhibit JJ kade khona ke ngaphansi kokushicilelwe la inkantolo ke bathi ngelanga lange-6 zaka-October ngomnyaka 2020 yena ke lapho ke kade esenza lo daba lolwazi kade analo ke nodaba likamsola wesibili ke kade liqhamukisile kolwazi lena ke le-confession nodaba le-confession ke bathi uBrigadier Gininda kulawa wabopha khona kumsola wesine ke lapho ke bathi futhi uBrigadier Gininda washo khona njalo noma waqedela ngenkulumo yakhe ke lapho ke ngesikhathi wabuza imibuzo ukuthi ngabe kwezenjani abopheke umsola washo ukuthi wathola ke umsola ngemuva ukuthi athole ke confession ke noma confession ke lapho ke statement kade enziwe lapho ku Brigadier Gininda ke loyo bekakhuluma lapho ke futhi wabuya kumele waqhathanisa phakathi kwelinye ke icala lo mbuso leli kade icala umbuso noBatman likade hlezi ke lapho ke la ngo-1960 volume 3 SA 535 la athi khona ke umsola kumele ukuthi ke lapho ke athweswe icala mhlawumbe atholwe necala ngendaba yokubulala ke lapho ke noma icala lokubulala ke lapho ke athi uma ungabe umuntu oyedwa ke lapho ke thize wenza ke udaba le-confession ke la afaka khona ke umunye umuntu wesibili ke kuyona ke udaba le-confession yakhona ke wabe futhi aqhubeka washo khona njalo ke malana nodaba lwenkulumo ke lapho ke bekakhuluma khona ke asho khona njalo ukuthi lapho ke futhi eqhathanisa kwelinye ke icala noma esho khona njalo lapho ke ukuthi umuntu wesibili mhlawumbe umuntu wesithathu noma ngaphambi kokuthi bahambisane ke lapho ke athi noma kunjalo mhlawumbe sithi noma omunye umuntu lapho efaka ke omunye umuntu ngoqondile mhlawumbe ukujulile ke kwicala lelo ke kepha loyo nto akumele ukuthi inkosi yenkantolo ke inake ke ngoba athi khona lapho kukhulunywa khona ke ku Skinner JA shothi judge ke kade besenza khona ke appeal ke lapho ke futhi wabuya futhi eqhathanisa phakathi kwelinye ke icala kade lihlezi ke khona ke njalo ke lapho ke icala lika R noNkosi ke lapho futhi noZulu 1950 volume 1 PH la bakhuluma khona ke ngodaba lolu qhathanisa phakathi icala leli kwesicelo sakho lesi ke futhi necala leli yana ke la khulumile khona ke uma ngabe ejobela inkulumo yakhe khona ke washo khona njalo lokhu ke akusho ukuthi khona ke umnumzana umsola wesibili ke ngesikhathi bekakhuluma khona ke njalo inkulumo yakhe kumele ihambisane noma inkulumo yakhe ihambisane inkulumo kaZungu uZungu kade ayisho ke lana noma mhlambe noma engayishilo ngendlela ke ejulile mhlambe ngendlela eqondile shaya isikhonkosini ke lapho ke futhi wabuya ukukhuluma khona ke njalo ke lapho ke washo ukuthi inkosi lapho ke malana nodaba lana ke iNingizimu Afrika lwenkosi zenkantolo ke kwamele ukuthi bangabheki kahlehle elikozana ukusebenza kwezemthetho kwangaphesha kwelwandle mhlamba kudulike ke ngenye ke indlela lapho ke washo ukuthi kwamele kwadulike ngendlela ke eqondile zomthetho ke balana ke iNingizimu Afrika ke kuphelana lapho ke uma usakhuluma ke ngodaba lezomthetho ke elwela ngaphansi kwa section 35 ngoba sakayijobelela ke lapho ke wabuya futhi wakhuluma khona njalo ke lapho ke ngodaba lezama bank record ke lapho ke lathi khona ke malana nodaba luka section 236 act ezomthetho ke lapho ke lana ke iNingizimu Afrika ke udaba lofakazi ke lapho bama-bank bama-accounting noma ama-recordings walapho ama-document wasemabhangi ke lapho ke awela ngaphansi kuka-exhibit EEE lapho kade kamsola wesine ke lapho ke lathi khona ke uma ngabe sobuka ngaphansi kodaba lolo lwamakhasi ke lapho ke xa ukhasi le-11 kuzifince ku-15 ke lapho ke athi phakathi kwesikhathi lapho ke siyi-28 zaka August ngomnyaka ka-2014 kuzifince ngelanga lange-30 zaka April ngomnyaka ka-2014 ke lapho ke athi ihlangothi lezombuso noma ithimba lezombuso ke lapho ke athi akukho la luveze khona ke ukuthi yena ke noma ngaphansi kwekhasi lesi-24 lapho ke ukuthi ngelanga lange-25 zaka October ngomnyaka ka-2014 kuzokufince ngelanga lange-27 zaka October ngomnyaka ka-2014 ukuthi noma sitshengisa khona ke lapho ke malana nodaba lwesikhathi lesi-24 athi futhi uma ngabe sejobela ke inkulumo yakhe ke lapho ke athi malana lodaba lwasemabhangi ke lapho ke athi akukho ke ama-record lapho ke asho khona ukuthi umswalo wesine ke khona ke into awayithola mhlawumbe imali awayithola ke kuyena ke umuntu kade qasha abanye abantu shothi yena ku-mastermind ke ngesingisi ke ekuthizini babulale ke umufi ke lapho ke futhi athi uma sesibuka lapho kudaba lama-bank records mhlawumbe ukuthi eshicelwa ngaphambi kwenkantolo ke athi futhi lokho kuyasho kuyahambisana futhi nenkulumo kamsola ukuthi yena akaze athole lutho noma akazi lutho ke ngodaba lolu ke futhi wabuya futhi wakhuluma khona njalo ke lapho ke ngodaba noma mhlambe uma sekhuluma ngofakazi ke bezoshicelelo lokamakhala ekhukhwini ke lapho ke kula khulume khona ukuthi umsolo wesibili ke kula khulume khona ukuthi umsolo wesibili ke uma ngasikhuluma ngodaba loshicelelo lokamakhala ekhukhwini wakhe ke noma ucingo lwakhe ke lapho ke lwanombolo ezilandelayo ke lapho ke u277139538001 ukuthi iyona ke inombolo kade kuyizo inombolo zakhe zocingo ke lezo ke athi ngaphansi kwezomthetho lapho section 205 ke lapho ke uma sebuka lapho uCornel Agwas ngesikhathi bekasho khona njalo ke athi lokhu ke futhi naye ukhulumile ngodaba lolo ke ngaphansi kwakumsolo wesibili ngomnyaka 2020 ke khuluma ngaphansi kwemibukiso ka-DD5 lapho ke futhi no-B ke lapho ke futhi washo ukuthi nje alukho ke ulwazi alitholile mhlawumbe ulwazi ade lusho khona njalo ukuthi umsolo wesibili ke sele waxhumana nomsolo wesine noma waxhumana nomsolo wesine ke lapho ke futhi waqhubeka njalo ojobelele watsho khona njalo ke mayelana nodaba lwesicelo saka 205 ke lapho ke loshicelelwa kwezocingo ke lapho ke zomnyaka 2014 ukuthi umnumzana Colonel Still washo ukuthi yena ke lokhu ke uma ngabe sekudluleke iminyaka isikhathi seminyaka emithathu ke bavama ukuthi bangakutholi lula mhlawumbe noma kushone lokho ke noma kucisheke lokho ke wabe futhi wakhuluma ke lapho ke ukuhlangana lapho ke kwabantu noma kuhlangana kokuyibhamu ke lapho ke la khulume khona ke ummeli washo khona njalo ngesicelo sakhe ke lapho ke wathi uma ngabe khona udaba lolu kwathi lokhu akubukho ufakazi mhlawumbe ufakazi okhethekile ke okusho khona njalo ukuthi umuntu oyedwa noma umuntu othizini ke lapho ke bekasebenzisana nabanye ke futhi besenza lolu hlelo ngendlela ukuthi bebazwene ke futhi ngemuva ukuthi babazwane ke beyiqembu ke lapho ke wabuya futhi wakhuluma waqhathanisa phakathi kwicala ke lapho lezombuso futhi icala la kaNkosi ke noma icala lombuso libhekene ke icala la kaNkosi ke lapho ke la ka 1988 volume 1 SACR 284 lapho ke bakhuluma khona kumele iqhathanisa phakathi kwicala lelo ke futhi icala leli esingalana ngaphambi kwenkantolo ke wabuya futhi waqhathanisa futhi phakathi kwelinye ke icala lapho ke la kaMakhubele libhekene nombuso lapho ke futhi noma Jeke futhi nabanye ke lapho ke bekanza isiqhathaniswa phakathi kwalokhu ezama ukwenza isibonelo noma udobe isibonelo edobela khona ke lapho ke inkosi yenkantolo ukuthi ile kahlahle bekakhuluma ngayo ke lapho ke wabuya futhi wakhuluma ngodaba lokaMsergeant Mandla Ricardo Masondo ukuthi uSergeant Mandla Ricardo Masondo washo naye ngesikhathi bakhuluma ilithufakazi bakhe la ngaphambi kwinkosi yenkantolo ke ukuthi yena usebenza ngaphansi kwezesiphoyisa ke lapho ke futhi lapho ke la sebenza khona ke usebenza ku-Provincial Tax Violence Unit kulomkhakha noma kule mboni ezamatekisi ke lapho ke lapho athi Provincial Organized Crime Unit ke ngesingisi ke uma ngabe sebeqedela ke athi yena ke wakhuluma ufakazi bakhe ke lapho ke washo khona njalo ukuthi ngelanga la nge-9 zaka February ngomnyaka 2015 kade asemsebenzini futhi ehamba ngesikhathi basemsebenzini bekahamba nomunye uzakwabo lapho ke uSergeant Dlamini ke athi ngesikhathi abasebenza khona njalo bathola ke ulwazi ngemuva ukuthi bathole ke ulwazi malana nomsolo wakhe lapho ke bese bahamba bamcinga kumsolo khona ke athi ngemuva ukuthi bamthole ke umsolo khona ke ngesikhathi usenza usesha kucala labo ke lapho ke bathola khona ke lapho ke 9 mm search republic law egcigcwele-ke lapho-ke izinhlamvu eziwu-15 ke kuyona-ke kade futhi khona-ke inhlamvu eyodwa kade ihlezi lapho ngaphambili-ke kuyona-ke lokozana leso sibhamu-ke leso-ke futhi atsho khona njalo basithola lapho kumsola wesithathu-ke esibhamu leso-ke futhi aqhubeka watsho khona njalo ukuthi wathi lokhu bakubhala ngaphansi kwecala bese baqhubeka bahamba bayeke Cleveland Police Station noma kwesikhumulo sase-Cleveland Police Station bese bafika bavula icala lapho-ke bese ngemuva ukuthi bavula icala ukuthi bathole-ke umuntu ephethe isibhamu ngemthetho-ke lapho-ke bese balibhala ngaphansi kwicala lase-Cleveland-ke lapho-ke bathi case Cleveland case 96/02/2015 SAP bathi 13/86/2015 bese lokho bakuvala-ke ngaphansi kwesikhwama-ke isikhwama sakhona bese bayiphala iy'nombolo ey'landelayo-ke bathi u-FSE 3 bese yaba ney'nombolo-ke bathi u-385083 ilokozana khona-ke bathi khona-ke ufakazi khona komunye ufakazi futhi naye waletha ufakazi bakhe-ke lapho-ke wakhuluma khona njalo-ke lapho-ke bathi ufakazi baka-Lieutenant Colonel Christine Mangena bathi naye khona kudaba wakhuluma noma khona-ke ufakazi owabuletha-ke lapho-ke naye washo khona njalo usebenza ngaphansi kwezama-ballistic section ngaphansi kwe-forensic science laboratory laqashwe khona-ke lasebenzela khona njenge-forensic analyst-ke lapho ke naye washo khona ukuthi ngomsombuluko-ke lapho-ke ngelanga lange-20 zakaJulayi ngomnyaka 2020 ke ngesikhathi kade senza umsebenzi wakhe-ke yena-ke lapho kumahhovisi wakhe-ke athi khona-ke lokuzana wayibhukha-ke lapho-ke isibhamu ekade asifakile isibhamu-ke lapho-ke futhi kade sihamba ney'nhlamvu-ke lapho-ke sase-Cleveland Police Station ngaphansi kwe-Cleveland case 96/02/2015 bathi SAP 1386/2015 bathi lokhu-ke yona kwakubhala-ke ngaphansi noma wakuthola-ke noma le mibukiso wayithola-ke bese ngemuva ukuthi ayithole-ke sebawayivula-ke ikulapho ingaphakathi kwesikhwama evidence bag-ke lapho-ke kade naleyo nombolo ey'landelayo-ke lapho-ke bathi u-PA 400081085 bese wakubhala-ke ngaphansi-ke lokho-ke ngesikhathi kade senze umsebenzi wakhe-ke lapho-ke ekubhala kulo daba lalecala lalapho-ke Phosphorus case 636/10/2014 athi bena-ke ngomsombuluko khona njalo ngelanga lange-27 zakaJulayi ngomnyaka 2020-ke ngemuva ukuthi athole lokhu-ke lesibhamu lesi futhi naley'nhlamvu lezi-ke bese wayibhukha yena-ke back-ke wazibusele emuva-ke lapho-ke Cleveland case Cleveland Police Station-ke zivaliwe ngaphakathi kwesikhwama-ke isikhwama sakhona kade sinaleli nombolo ey'landelayo-ke lapho-ke bathi u-PA 40003043332 bese-ke lokho kwakwenza ngelanga elilodwa-ke bese waqeda lapho kwafaka ngaphansi ku-Cleveland SAP 13 store-ke lapho-ke ngaphansi lokho kusenziwa-ke ubrigadier Gininda-ke bathi u-Lieutenant Colonel Mangena-ke waletha ufakazi bakhe washo khona njalo ukuthi yena-ke wabhala le report leyo kade ngesikhathi ayibhala ngaphansi kuka-section 212 open bracket 4 bathi close bracket bathi open bracket A close bracket futhi no 8A lapho-ke ngaphansi kwezomthetho we-Criminal Procedure Act 51 of 1977 okubhaliwe-ke lapho-ke kwimibukiso ka-X 13C bathi khona-ke ufakazi kade ukhulumile lapho-ke lapho ngesikhathi babuza-ke imibuzo abameli-ke lapho-ke uDumelo Madlala kade kubuza-ke lapho umnumzana-ke uRamsipili-ke ngesikhathi bekambuza khona njalo wambuza umbuzo kokuthi-ke lapho-ke ingabe angasho yini ukuthi isibhamu lesikhathi ngabe kade sinesondo kusona-ke eceleni-ke noma kade singenayo into ebukeka njengathi isondo kusona-ke ngesikhathi kade ngaphambi kwenkosi enkantolo-ke bathi yena-ke washo ukuthi uDumelo Madlala siwaphendula-ke khona-ke lapho-ke futhi ngesikhathi bekaphendula-ke lapho-ke washo ukuthi lokho-ke kubutshakala ngathi kade likhona-ke isondo-ke lapho-ke kepha thina kakaze asibukisise kahlehle noma kakaze ukuthi athole isikhathi esigcwele sekuthizeni asiqaphe kahle isibhamu sasibuke kahlehle lapho-ke bese lokho bathi washicelelwa ngaphansi lana-ke ngaphambi kwenkosi enkantolo-ke ngelanga lange-8 inyanga yesi-8-ke lapho-ke ngomnyaka 2023 lapho kwikhasi lesithupha-ke kumugqa we-16 kuze kufince kumugqa owama-22-ke bakhuluma futhi khona njalo lapho umnumzana omnisi-ke ngesikhathi bekabuza-ke khona njalo-ke bathi umnumzana omnisi nakhona bacaphule lapho-ke wathi okay yebo ngiyabonga-ke manje bathi nawo umbuzo oyedwa-ke ngabe mhlawumbe yini-ke into ehlukile kule sibhamu angabuye akhulume ngaso-ke mayelana nodaba lesondo leliyana-ke bathi uMadlala wathi lapho-ke yebo angasho sekashilo njalo-ke kepha ngesikhathi bekasibuka leso akaze athole-ke isikhathi sokuthi asibuke athena-ke wasibuka la kusona-ke la ehlangothini la ngaphambili kusona-ke bese lokho wabuya futhi uphumile qhathanisa phakathi kwelinye icala noma mhlawumbe wenza isibonelo ngoqhathanisa phakathi kwelinye icala ke lapho ke la kade khona ke uWalter Meyer ke lapho uJA lapho ke uR versus Blom ngo1939 AD 188/02 kufika lapho ku203 lapho ke wathi khona ke into ezimbili kade bekhulumile ke ngazo ke lapho ke ukuthi uma ngabe lokho kusenzeka ngabe kuyini into emele ukuthi kahlehle ibukisiswe futhi babukisise ngokhethekile lapho ke wabuya futhi wakhuluma khona njalo kumele jobelela khona njalo ke lapho ke esho khona njalo ethi malana nodaba la kaTumelo Madlala noma mhlawumbe ufakazi kade bukhulunywe lapho kuTumelo Madlala ke ngesikhathi kade abuzwa ka imibuzo ke lapho ngaphambi kwenkosi enkantolo kabameli ke ngodaba lwase ballistic reports ke lapho ke bathena akunalutho alikhumile ukuthi mhlawumbe ke ikhona ke into ekhethekile ngohlamba ngathena ke khona ke ngaphakathi kodaba lo kade libonile ke noma mhlawumbe into mhlawumbe engenze thina angayingabazi ngenkulumo yakhe kade ayikhuluma la ngaphambi kwenkosi enkantolo ke lapho ke wabuya futhi wakhuluma khona njalo ke ummeli wenu ke lapho ke washo khona ukuthi inkosi enkantolo iyacela ukuthi ibuke ke lapho malana nodaba lwama principles la mahlanu ke kade akhulumile ngawo kulicala la kaMgedezi ke noma mhlawumbe lesinqumo secala la kaMgedezi kade bekhulumile ke ngawo ke ukuthi umuntu kumele ukuthi abe khona ke kwindawo esigameko ke iphuzu loqala ke lelo ke bese lesibili abe nalo ke ulwazi ukuthi bayahamba ke bohlasela ke lapho ke bese iphuzu lesithathu ukuthi ke lapho ke benze ngenhloso ke ekuthizini benze ke lokho kade bekwenza ke lapho ke noma futhi kunye ukuthi naye futhi athathe isikhangiso ekuthizini ahambe naye okwenza ukuhlasela ke noma mhlawumbe abe nolwazi lokuthi bayahamba vele bekwenza le nto kade beyenza ke futhi enye benze ngenhloso ekuthizini babulale ke lapho ke uma ufike lapho ke kushuthekile ama principles amahlanu beyakhuluma ke ngawo ke bese wabuya futhi washo khona njalo ukuthi malana nodaba lwalecala leli ke uyacela ke ukuthi inkosi enkantolo ke umnumzana ke malana nodaba lomacala la ithimba yasho khona njalo ukuthi ithimba labashushisi ke lapho ke lehlulekile ekuthizeni ke liqhamukise icala ngoqondile malana nomsola kwesine lapho ke malana namacala icala lesine icala lesihlanu ke lapho ke manje washo khona njalo ukuthi kwamele ukuthi umsola wesine ke lapho ke bamdedele kuwona ke wonkana lamacala kade bemthosa wona ke yilokho nje kuphela kade akulethile ummeli wenu malana nodaba lwakhe lesicelo.
Yes, sir.
As you could, please, my lord, we ready to start with our submissions. However, the fact of the matter is that we will not finish this afternoon.
Yeah, so
The question is whether should we start and then continue tomorrow or just continue tomorrow?
what's the view of the other
In other words,
councils?
commence tomorrow.
What's the view of the other councils?
My view, my lord, is I think it will be, the interest of justice will be best served if we start the submission by our colleague on a clear mind, my lord, because we also need to concentrate. We have overly concentrated today. I'm afraid if we were to start another chapter, a new chapter in this application, we might miss a factor or two,
All right.
as we are noting down, my lord. Thank you.
Yes, Mr. Ramsepili.
This is my lord, I do concur with Advocate Munesi that we should start in the morning, my lord.
Thank you, my lord. I have no objection to the request to start tomorrow
What is the
morning.
request? Because
To
we are
roll over.
finished.
To roll over.
No, I'm just joking.
Yes.
Yeah, and Ms. Mishodo?
No objection, my lord. We can roll over until tomorrow.
Yeah, in the meantime, this court, in terms of section 186, I haven't yet made a final decision, but I think in the interests of justice, it would be fair to record the evidence of Mr. Makela. Is it Mr. Makela, the gentleman who was at the garage? Allegedly at the garage.
No, but he's passed on.
Yeah, I know that. That's
Yes.
why I'm saying 186.
Yes.
Which section do we normally use?
Is
I
it-
know it's evidence rules, section 3,
Yes.
1988.
Yes, that's,
Yeah, in the interest of justice, when you want to call a witness like this, because as Mr. Mwamalo was arguing, making submissions, I'm thinking that this witness, allegedly, he saw something. According to Ginanda.
yes, Mr. Makaleni.
Makalenia,
yes,
and
yes.
Ginanda is the one who took
His statement.
The statement from him. Are you aware of that case?
Yes.
State versus KLB. It's in Britain, 1983. But it was used in South Africa by two judges, Sishi and Madondo. Are you anybody aware of that case? I can bring it tomorrow.
Yeah.
You've never heard of that case, sir?
Yeah.
Mr.
Well,
Ramsepit.
Maybe I had one.
Yeah. So what he did is, there's a case in Britain which some of our courts in South Africa have used. This gentleman was charged with rape in Britain. And he was subsequently, after being charged, he died. He died. But the detective who took the statement from him was still alive. And the full court in England ruled that because this evidence may be useful in trying to sort out this very case before the full court there, we can listen to the evidence through the investigating officer. The only proviso was that the investigating officer should have sworn in this witness and told him what is the effect and the difference of adducing evidence on a statement under oath, and what are the consequences if you are lying. You remember that?
yes.
That's it. And it was allowed, that case, on that basis, that it would be in the interest of justice to listen to this evidence through the investigating officer, because he is the one who contemporaneously took the statement of the deceased. Like in this case, it's Geninda who says he took the statement.
No, I think it was taken by someone else.
Is that so? It's not
Yes.
Geninda.
No, it's not Geninda.
Just check for me.
Yes.
Okay.
No, it's definitely
Everybody
someone
can
else.
check for us, so that we must see whether it's a waste of time or not. So you say it was taken by somebody else?
Yes.
Who? Mohani?
We'll just get
Mamfundisi? Who?
hold of the states.
Who?
We just want to verify now, but
How
our
many investigating
recollection.
officers were there?
Yeah. Yes, the court will recall that there were different teams working on this
Oh, by the
matter.
way, yeah, okay, fine.
So it was taken by the
Possible.
team that
Oh,
was
all right,
involved
okay.
right at the beginning.
Okay, fine. Okay, let's meet tomorrow then. We'll check that.
Just print it for us.